Stream check, 1, 2. Stream check, 1, 2.
All right, let's go on the record. Good morning. Today is April 18th, 2024, and the current time is 9:05 a.m. This is day 4 of the Ameren securitization hearing. The Commission has set aside this time today for the evidentiary hearing in the matter of the petition of Union Electric Company doing business as Ameren, Missouri, for a financing order authorizing the issue of securitized utility tariff bonds for energy transition costs related to the Rush Island Energy Center. And that is file number EF-2024-0021. My name's John Clark. I'm the regulatory law judge presiding over this hearing today. Commissioners will be in and out during the course of the day. Some of them will appear via WebEx. Some of them will appear in person. At this time, I'm going to ask counsel for the parties to enter their appearance for the record. On behalf of Ameren, Missouri.
Wendy Tatro, that's spelled T-A-T-R-O.
Thank you, Ms. Tatro.
Jim Lowry, also on behalf of Ameren, Missouri, L-O-W-E-R-Y. Thank you, Judge.
Thank you. And they are doing this absolutely correctly because we have a new court reporter today. So the first time you go through, you might want to spell your name if it's unusual. On behalf of the staff of the Commission.
Travis Pringle, Nicole Mers, and Jeff Keeble.
Thank you, Mr. Pringle. On behalf of the Office of the Public Counsel.
Nathan Williams, on behalf of the Office of the Public Counsel and the public.
Thank you. On behalf of Midwest Energy Consumers Group.
Good morning, Your Honor. Tim Opitz on behalf of MECG.
On behalf of Missouri Industrial Energy Consumers.
Diana Plesha, P-L-E-S-C-I-A.
Renew Missouri has been excused, though they have an issue up today. The Natural Resources Defense Council has been excused. AARP and Consumers Council of Missouri, they were granted leave to be excused if they needed to be. They may show up. And the Sierra Club likewise was excused from this proceeding. I've got a couple preliminary matters, and I also know that the parties do as well. So I guess we will start with mine. I guess first off, it was pointed out earlier in the hearing to me that there are 3 court decisions, district court decisions, involving this case. And my understanding is that 2 of those court decisions are attached to the testimony of Mr. Keith Majors, but that one of those is not. And I believe it's the 2017 and the 2021 decision are attached, if I'm correct, and it's the 2019 that is missing.
That is correct, Judge.
Is any party planning on entering that, or is that something where I need to ask for it to be a commission exhibit?
Judge, this is Nathan Williams for Public Counsel. I believe there are actually 5 decisions in that federal case that might bear on this one. There are a couple of summary judgment determinations as well. I believe all of those are published opinions. Mm-hmm. If you want them to be part of the record, I'd be happy to provide copies.
Please. I think that would be great.
Thank you.
Now, in terms of the logistics of whether those need to be commission exhibits or a witness needs to offer those, or whether I can take official notice of them.
We believe, Judge, this is Travis Pringle from staff, one of the summary judgment opinions.
Was entered already, yes.
Mm-hmm.
And I'm aware of that. It's behind me on that counter. But thank you for letting me know. But it sounds like there may be one other out there.
We know the remedy one, we don't believe that one was attached to anything.
Okay. I would like to have all of those decisions in the record. I believe they're extremely relevant, and I believe they will be assistive to the commission in determining many of these issues.
I apologize. I believe I misspoke. I think the 5th one is the 8th Circuit opinion.
Okay, so we're down to 4, and I have 3. All right, I may, if it doesn't come up, I'll address it again tomorrow morning. The second issue is I don't know if staff intended to offer their proposed order or not as an exhibit, and I don't know that it's necessary as it being a proposed order, and that's fairly common. So I just thought I'd throw that out there and leave it as it is.
Yeah, I'll get back to you on that one, Judge.
Thank you. Now, I understand that there are some preliminary matters from the parties, so whomever can speak first.
Judge, all of the council have discussed this, and we think that issues 16, 17, and 20 are closely related and have a commonality of issues, and it'd be more efficient just to consolidate them when they come up, when 16 comes up.
You said 16, 17, and 18?
20. 16, 17, and 20.
And what are those issues, just so I don't have to just play with
16 is
papers.
allocation of the revenue requirement.
Mhm.
17 is, like basically I'll call them miscellaneous tariff issues.
Mhm.
And then 20 is actually a tariff issue too. It's language, whether there should be language in the tariff dealing with if customers switch because of a territorial agreement.
If I were to consolidate two of those, which two would you prefer, or would the parties prefer?
Well, definitely 16 and 17. But Wills and Sarah Lange are also, they're the only two on 20, and they're also on 16 and 17, so.
Okay, is there any opposition to consolidating those three? I hear and see none. Does anybody, there is one party who's not here who's been coming in and out, well, two parties, one attorney, and that's AARP and Consumers Council of Missouri. Are those issues of interest to them?
I don't think they are, but Ms. Volsteck spoke to Mr. Kaufman just a moment ago, and he indicated he did not have any objection to consolidating the issues, those three issues. Pleasure, I'm sorry.
That's okay.
Is that correct?
I knew you changed your name, but
Yes, that is correct.
Thank you. Now, we have a virtual court reporter today, and what that means is that all that court reporter can hear is what's going through the microphone. And I was informed yesterday that in the afternoon, and I know everybody gets tired and there's a tendency to lean away from the microphone, but I understand that in the afternoon yesterday it was very hard to hear what the attorneys were saying. So I'm going to ask that everybody be mindful of that today, and I will try and bring it to people's attention when it comes up as an issue, okay?
Judge, I have one issue.
I'll get to it in just a second.
Okay.
I haven't granted. I have no problem with consolidating the three. The reason I'd suggested two is because I don't want a lot of, my questions are a little spread out, and it means that it may take a little longer for me to go through if I have multiple questions for the same witness over multiple issues. So we'll just see how muddy that gets. But I will grant that request from the parties. I also have, my understanding is that Public Counsel also has a preliminary matter. Go ahead.
Yes, our witness for issue 17, Ms. Mantle, needs to be completed by early afternoon at the latest. And that's one of the issues amongst the three that have just been consolidated.
Well, there's a couple ways we can handle that. We can either bump those to the front, or we can keep the issues in the order they are, and I can bump Ms. Mantle to the front of the witness list for those issues.
Whatever's the commission's pleasure.
Your Honor, we would be supportive of Ms. Mantle going separately. We were concerned primarily about allocation and tariff being together, or allocation at least having all of the witnesses on that issue be together. So if Ms. Mantle, if it's more convenient for her, it's fine with us if she goes separately.
You mean
It is-
separately or out of order from the
I-
issue entirely?
Out of order.
Okay, well, why don't we take the issues in the order they are right now, and if we start to run out of time, we may just take Ms. Mantle separately. Are there any objections to that?
no objection.
No
I see
objection,
none.
Judge.
I'm sorry?
No objection.
Thank you, Mr. Pringle. All right, we left off yesterday with issue 12, and we are ready to start issue 13, which is community transition costs. What amount of community transition costs should be financed using securitized utility tariff bonds? And the first witness for that is for Ameren, Missouri. Ameren, you may call your first witness.
My first witness, Mitch Lansford. And Your Honor, it will probably be easy for the court reporter to know when I'm talking. But how do attorneys need to say their name when, like, objection and include their name? So for the record, she knows, I've never done a
I
virtual
think
before.
it would be helpful, at least until they get to know your voice a little bit, if introductions were made. I'm not aware of how much she can see of who is speaking, and the camera tends to bounce around a lot. So yes, I would appreciate it if, before you ask a question, you would say your last name. So thank you very much for bringing that to my attention. That's very helpful. And Mr. Lansford, I'm going to swear you in again. Do you solemnly swear or affirm that the testimony you're about to give at today's evidentiary hearing is the truth?
I do.
Please be seated. Ameren, Missouri, go ahead.
This is Tatro. Mitch Lansford has been on before and will be on again, so I am just going to tender him for cross.
Thank you. Any cross from MECG?
No cross, Your Honor.
Any cross from MIEC?
No cross, Your Honor.
Any cross from the commission's staff?
Yes, Judge, thank you. And this is Travis Pringle on behalf of the staff. Good morning, Mr. Lansford.
Morning.
Now, is there anything preventing the company from claiming any of these community transition costs as charitable deductions on its taxes?
And when you ask about charitable deductions on its tax return, how do you what do you mean by that, I guess?
For example, contributing to a community group for any kind of, community development, especially any kind of nonprofit group, could the company claim those as charitable deductions on its taxes?
The answer is yes, it could claim these as charitable deductions, but I think there's a misconception as to the importance or what a charitable deduction means in terms of a corporate tax return. If you think about individual income taxes, when you make a charitable contribution, you get a deduction that you might not otherwise receive. When you think about corporate income taxes, making a payment, incurring an expense like a charitable deduction is really no different than any other expense that a company might incur. So you think about paying a contractor for an O&M cost, that is a deduction. If the amount is $1 million, you get a $1 million deduction. If you make a charitable contribution you will get also a $1 million deduction. So there's really this misnomer that from a corporate income tax perspective, there's some sort of incremental or extra benefit that a company might receive beyond just a normal expense or a normal cost.
Are these costs more voluntary on behalf of the company, or are they required under some kind of state or federal statute?
These costs are not required under a state or federal statute, as far as I'm aware.
Thank you, sir. No further questions.
Any cross-examination from the Office of the Public Counsel?
Thank you, no.
Are there any commission questions?
No,
Chair
thanks,
Hahn,
Judge.
Go ahead.
Good morning, Mr. Lansford.
Good morning.
Just for clarification, an expense like this would reduce the company's overall tax liability,
Would reduce taxable income, yes, just like any other expense.
right? Thank you.
Are there any other commission questions? I heard no from Commissioner Holzman. I hear no other questions. Mr. Lansford, the amount of property taxes included in Ameren's last rate case, ER 2022-0337, were trued up to the end of 2022. Has there been any change to the amount of property taxes charged to the ratepayers since the rates from Ameren's last rate case went into effect?
No changes in customer rates relating to property taxes that I'm aware of.
Thank you. That is the only question I had. Is there any recross based upon commission or bench questions? MECG?
No recross, Your Honor.
MIEC?
No recross, thank you.
And for the court reporter, I'm using MECG for Midwest Energy Consumers Group and MIEC for, is it Missouri Industrial Energy Consumers?
Correct.
Thank you. Any recross from the commission staff?
No, Judge, thank you.
Any recross from the Office of the Public Counsel?
No, thank you.
Any redirect from Ameren, Missouri?
Tatro, none, thank you.
Mr. Lansford, you may step down. Thank you very much. Ameren, you may call your next witness.
Ameren, Missouri calls Steve Wells.
Mr. Wills, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes, I do.
Thank you. Please be seated. Ameren, go ahead.
Could you please state your name and job title for the commission?
My name is Stephen Wills, and I'm the Senior Director of Regulatory Affairs for Ameren, Missouri.
And are you the same Stephen Wells who filed direct testimony, which has been pre-marked Exhibit 19, and sir rebuttal testimony, which has been pre-marked 20, which has confidential and a public version?
Yes.
Do you have any additions or corrections to your testimony?
No, I do not.
If I were to ask you the questions that are contained within your testimony, would your answers be the same or substantially similar?
Yes.
Mr. Wills will be up, so again, so I will wait to offer. I will tender him for cross.
Okay, he also has sir rebuttal testimony, I believe, doesn't he? No?
No, I do
Am I
not.
misunderstanding that?
I don't believe that he does.
I do not. Thank
Okay,
you.
then I misread that. Thank you. Any questions for Mr. Wills from MECG?
Not on this issue, Your Honor.
Any questions for Mr. Wills from MIEC?
No questions, thank you.
Any cross-examination from staff?
No, Judge, thank you.
Any cross-examination from the Office of the Public Counsel?
Yes, Nathan Williams from Public Counsel. Mr. Wills, when did Ameren, Missouri decide to permanently close Rush Island?
I believe, going off my recollection, I think the record would probably already reflect this, so it might be more reliable than my recollection, but I think that was in December of 2022? 21. I'm sorry, December of 2021. Sorry, I'm going off my recollection there.
And did Ameren, Missouri notify taxing authorities of its decision?
At some point we did. I can't tell you. I don't think at that specific time we did, and I don't know specifically when, but I think there have been conversations at a certain point in time. I don't know when those were. I wasn't involved in the conversations.
Were they at or near the time of the plant closure decision?
I don't know.
Well, when did you become aware that Ameren, Missouri had notified any taxing authorities?
I can't remember the timeline of when I've had conversations around that, but there have been a number of conversations between the company and the school district and the county, and I don't specifically know the timeline on those.
Did any occur in 2022?
Not that I'm specifically aware of.
Did any occur in 2023, to your knowledge?
I'm not sure. I think maybe so. I'm not sure. I don't remember the specific timeline on that.
Did any occur before June of 2023?
Not that I'm aware of.
Did any occur before October of 2023?
I don't know.
And which taxing authorities did Ameren, Missouri notify to your knowledge?
I mean, I guess I technically don't know who the entity that is the taxing authority is sitting here. I know we've spoken to county officials, to school district officials. So I guess I would, when you asked me whether I've spoke to the taxing authority, I guess I should have qualified my answer that we've spoken to relevant folks that are in the county and in the school district. I don't know whether or not they themselves are a taxing authority.
When you say relevant entities, are you talking about entities that rely on tax proceeds?
Yes.
Did you speak to any entities that rely on tax proceeds aside from those in Jefferson County?
Not that I'm aware of on the specific issue.
And Rush Island's going to, the closure of Rush Island's going to have tax impacts elsewhere, correct?
Sure, but not the kind of disproportionate impacts that it'll have on Jefferson County.
What's the basis for your knowledge of the impacts that Jefferson County will incur due to, tax-reliant entities in Jefferson County will incur as a result of the closure of Rush Island?
A number of conversations with the school district superintendent and other communications internally with Ameren and in between us and county officials.
So it's not your personal knowledge, it's what someone's told you?
Well, I know that I'm aware of how much taxes we pay, so I'm aware, from my personal knowledge, I know what kind of the dollar impact and the reduction of taxes available to them. What we really used the conversations there was to put it into an order of magnitude in terms of what that means to their budgets.
So would Ameren, Missouri have known that back in December of 2021?
I presume so, yes.
Why did Ameren, Missouri not have the discussions until, to your knowledge, I believe it was after June of 2023?
This is Tatro. I'm going to object to form of the question. He misstated what Mr. Wills testified to. He didn't say we didn't have that there were no conversations. He said he wasn't in the conversations.
Mr. Williams?
I can rephrase the question if I misstated it in the fashion that Ms. Tatro says I have. I believe you said that you were unaware of any conversations prior to June of 2023 with taxing authorities, correct?
I'm personally unaware of any, yes.
Would you have been aware of any had they occurred before then?
I think I may or may not have been. I think it's possible I could have been, but it's possible I could not have been also.
Why would you not have been?
Because we have community relations departments that interact with communities and counties on a regular basis, and they don't incorporate me into all of those conversations or report to me on all those conversations.
Did Ameren, Missouri engage in the outreach towards affected tax authorities or let me try it again. Did Ameren, Missouri do any outreach to entities that would have tax revenue impacts by the closure of Rush Island?
I think we've discussed that we have had communications with entities like the school district and the county that will be affected by the tax reductions.
Well, you said you had conversations. I'm asking who initiated those. Did Ameren, Missouri initiate any of those conversations?
I believe so, but I'm not 100% sure of that.
So you did not personally initiate any?
No,
of
I
them?
did not.
To your knowledge, when were those conversations initiated?
I do not know.
But you're not aware of any before June of 2023?
I'm not personally specifically aware of any in that time frame.
No further questions at this time.
Any questions from the commission? Chair Hahn has a question.
Morning, Mr. Wills.
Good morning.
I'm assuming you're familiar with the securitization statutes.
Yes.
I assume you probably also have them memorized, but
I don't know that I would go that far.
when I'm considering this, I can't seem to find anywhere in the statute where community transition costs or anything similar is an allowable expense for securitization purposes. Can you help me out there?
Yeah, I mean, I don't think you'll find anything that directly points to this nature of cost, but I think what you'll see is that the costs that it describes are costs including a list of things, but not limited to. And so I think that the statute gives the commission some discretion to consider other costs that you can directly trace to the energy transition event, which, I think to the extent, and I will say that I think that this is not a cost that we think you're statutorily obligated to approve. Our recommendation is that it would be good policy to consider the impact on the community, and that, to the extent that we do incur a cost to mitigate that impact, it would be directly related to the energy transition event. So you do have to read it into the costs are not limited to those identified there, and kind of look at the nexus of the nature of this cost relative to the energy transition event that's occurring.
Yeah, I appreciate that. When I was reading it, this is not even something like items in the list. So I was trying to figure out, people have different interpretations and oftentimes, may not just see it or how their relationships. So I'll continue to examine the list and try to figure out. But face value, I couldn't find it, but appreciate the discussion. Thanks.
Sure, thank you.
Are there any other commission questions? I hear none. Is there any recross from MECG?
No, thank you, Your Honor.
MIEC?
No questions, thank you.
Commission staff?
Yes, Judge. Good morning, Mr. Wells.
Good morning.
And you recall your discussion with Chair Hahn regarding these are not statutorily obligated.
Yes.
If the commission were to rule that none of these community transition costs can be securitized, will the company move forward?
I don't know the answer to that. I mean, that's a decision that would be made by Ameren's senior leadership. I don't know.
So the current plan is only if the costs are securitized.
The only decision that I'm aware of that has been made is that if the costs are securitized, then yes, obviously we would make the payments to the county.
Thank you, sir. No further questions.
Public counsel?
Yes, please. Nathan Williams again. In response to Chair Hahn, you said that it would be good policy to consider community impacts. You recall that?
I do.
Would it not also be good, or wouldn't part of that good policy and addressing community impacts to give advance notice that the taxing revenues will be dropping off in the future because of a plant closure?
I don't know if I would call that policy. I would say that might be a good practice generally, and I do think we have given some advance notice. I couldn't speak to the exact timing of that notice, but we have had some conversations around that. But I don't see that necessarily as a policy question. That's just a question of communications with the entities that we interact with.
No further questions, thank you.
Any redirect from Ameren, Missouri?
None, Your Honor. Thank you.
Mr. Wills, you may step down.
Thank you.
I believe the next witness is from staff. Staff, you may call your witness.
Thank you, Judge. Staff calls Mr. Keith Majors to the stand.
Mr. Majors, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at today's evidentiary hearing is the truth?
I do.
Please be seated.
Sure.
Ameren, or staff, go ahead.
Thank you, Judge. Mr. Majors will be coming before us a few more times in this hearing, so we will not be moving to enter his testimony at this time, but I do tender Mr. Majors for cross-examination.
Any cross-examination from MIEC,
No questions.
MECG,
No, thank you.
Office of the Public Counsel,
No, thank you.
Ameren, Missouri?
No, thank you.
Are there any commission questions for Mr. Majors? I hear none. Mr. Majors, you may step down.
Thank you.
I believe the next witness is from Public Counsel.
Nathan Williams for Public Counsel. I call John Riley.
Mr. Riley, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at today's evidentiary hearing is the truth?
I do.
Thank you. Please be seated.
Mr. Riley, your testimony has already been marked, and you've been up before and testified. I believe this is the last time that you have an issue that you're testifying on before the commission. Is that correct?
Yes, sir.
I offer,
I believe it's 207 and 208.
you are correct, Exhibits 207 and 208.
And those are the rebuttal and surrebuttal?
They are.
Any objections to admitting Exhibit 207, the rebuttal testimony of Mr. Riley, or 208, the surrebuttal testimony of Mr. Riley, onto the hearing record? I hear none. Exhibit 207 and 208 are admitted onto the hearing record.
I tender Mr. Riley for examination.
Any questions, any cross-examination for Mr. Riley from MIEC,
No questions.
MECG,
No, thank you.
the commission staff?
No questions, Judge. Thank you.
Ameren, Missouri?
No questions.
Are there any commission questions? Mr. Riley, you may step down.
May he be excused as well?
Yes, he may. While we're between issues, I'm going to say briefly, when this hearing started this morning, I said we were on day 4 of the Ameren, Missouri evidentiary hearing. It has been brought to my attention that we did take a witness out of order. So technically, that would make this day 5 of the evidentiary hearing. So I just wanted to note that for the record. Now, let's move on to issue 14, upfront financing costs. What amount of upfront financing costs should be financed using securitized utility tariff bonds if A, Rush Island is retired September 1st, 2024, and B, if Rush Island is retired October 15th, 2024. Should the costs associated with the company's witness, homestead, and more be included or excluded from upfront financing costs? So we've got an A and a B. Ameren, Missouri, I believe you have the first witness.
Yes, I would call Mitch Lansford to the stand.
Mr. Lansford, I'll remind you you're still under oath and you may be seated.
I tender Mr. Lansford to cross.
Any cross-examination from MECG,
Not on this issue, Your Honor.
MIEC,
No questions.
the commission staff,
No questions, Judge. Thank you.
the Office of the Public Counsel?
Not at this time, thank you.
Are there any commission questions? Chair Hahn has a question.
Good morning again.
Good morning.
So part of this question is over whether or not Mr. Homestead and Mr. Moore's testimony should be included or excluded from the upfront financing costs. From my recollection, Mr. Homestead provided testimony primarily only relating to the NSR permitting decision. Is that right from your, I mean, it's a broad stroke, but is that right from your recollection?
From my understanding, yes.
And I think Mr. Moore is also the same, but I'm trying to recall that.
From my understanding, that's also the case.
And the NSR decision and regarding permitting and whether or not to pursue permitting based upon what was known at the time does not actually have to be decided in this case. Is that right?
That's probably beyond my scope or knowledge of
Yeah.
the issue here.
And I wouldn't ask you, except for you're the only witness for Ameren for this subject.
We do have another witness, Chair
Okay.
Hahn. It's Steve Wills.
Okay, he's not on my list.
That would be my
I'll
mistake,
ask him.
Chair.
Thanks.
Mr. Lansford, securitized utility tariff bonds are not the only kinds of bonds Ameren issues, correct?
Correct.
Ameren issues other kinds of bonds that are not related to this securitization in any way.
Environmental bonds, corporate issuances, correct.
Are the upfront financing costs to issue securitized utility tariff bonds similar or different from the upfront financing costs to issue other Ameren Missouri bonds?
On the whole, I mean, a lot of the same topics exist across different financings. A lot of the same cost streams do exist. But I wouldn't say that all are applicable to every type of other corporate issuance.
Can you think of any that might be different from the securitized to to the regular bonds that are issued by Ameren?
Yes, just looking at Schedule MJLD3 here, just in terms of a list, as I think of line 6, SPE organizational costs, those I don't think would have to exist with the standard corporate issuance. That's for setting up the special purpose entity. Similarly, and there are probably a few other categories that may be specific to a securitization issuance.
But those are the only ones that come to mind?
At this moment, yes.
Can you think of upfront financing costs in this securitization specifically that might not be included in a regular Ameren bond issuance?
Judge, that's the same question, I think.
Essentially, I was just coming at it from a different angle.
Okay. I think some extent of most of these categories would exist in a normal corporate issuance or other types of debt that the company's issued.
Thank you. Any recross based on commission or bench questions from MECG?
No, thank you, Your Honor.
MIEC?
No questions, thank you.
The commission staff?
No questions, Judge. Thank you.
Public counsel?
No, thank you.
Any redirect from Ameren, Missouri?
Yes, please. Mr. Lansford, the judge asked you questions about the difference in upfront financial costs for other bonds beyond securitization bonds. Do you remember that conversation?
I do.
And are you familiar with the securitization statute?
I am, yes.
Do you know how the costs of this PSC proceeding are handled?
How the costs of this PSC proceeding are handled?
Yes,
As-
so for Nash Long as the attorney for Moore and Homestead and Mr. Lowry, how are those costs handled?
Yes, those are legal fees, and they are included in the upfront financing fees here. Line 2, And as I was, interacting with the judge, I think we also incur legal fees as in other when issuing other corporate debt. Could there be a distinction between the different types of legal fees? I guess potentially.
Thank you. I have no further questions.
Thank you, Mr. Lansford. You may step down. Ameren, you may call your next witness.
I call Stephen Wells.
Mr. Wills, I'll remind you you're still under oath. Please be seated.
I tender Mr. Wills for cross-examination.
Any cross-examination from MECG,
No, thank you, Your Honor.
MIEC?
Yes, we do have some questions. Good morning, Mr. Wills. How are you?
I'm fine, how are you?
Good. Mr. Wills, referring to your testimony at the bottom of page 5,
Are you talking about my direct or my sir rebuttal?
I'm sorry, I'm talking about your direct.
My direct testimony. Let me turn there, just give me a moment. Okay.
Okay. Is it correct that the energy-based collection of securitization costs that you put forth in your direct testimony was chosen to mirror the recovery method from the recently concluded Liberty securitization case and the recently concluded Evergy securitization case?
Are we taking this topic now? I think I'll be back up on the stand again later for this. But I mean,
Ms. Lange, you're not the attorney here. Please be seated.
I mean, if you'd like me to take this topic now, I mean, I can answer that question, or I think
I'm
that's
sorry, I think I jumped again. So I can hold this in for our next, for when the issue comes up. I thought we were moving to his issue. I'm sorry.
Okay, so you have no cross-examination on this witness? On this issue?
No, thank you.
Any cross-examination from the commission staff?
We're on upfront financing costs, no questions.
Any cross-examination from the Office of Public Counsel?
No, thank you.
Any commission questions for Mr. Wells?
Yes, it's me again. Okay. So you heard the question that I posed. Well, actually, I didn't pose a question. I can't remember if I posed a question or not. From my recollection, Mr. Holmstead's testimony and Mr. Moore's testimony is primarily around the decision whether or not to seek NSR at a point in time, based upon what they knew at the time,
I
or
think
the
that,
company knew at the time. Sorry.
Sorry, I think that's a fair characterization of the topics that they covered, Chair
Okay.
Hammond.
What decision do you think the commission has to make in this particular case?
So there's obviously been a lot of discussion about that this week, and I do think that, as Mr. Lowery indicated, kind of in an exchange with you during maybe one of the openings or many openings, I think that the retirement decision itself in December 2021 is a must to consider, right? I think that is, statutorily kind of required. I think when you're thinking about our incurrence of costs on the NSR issue, though, you should think about the perspective that, we were defending against. There is a prudence allegation that is asking for a $34 million write-off from the Office of Public Counsel in this case. So you might take different approaches to addressing that issue, but from the perspective of the company incurring the costs of Mr. Holmstead and Mr. Moore, those were certainly costs that we think made perfect sense for us to defend ourselves in this proceeding, given kind of the allegations there. But I will, so stepping back, your question is, what do you have to decide? You have to decide that retirement issue. I kind of felt like maybe you were extending, since this is the topic of the costs of Homestead and Moore, just putting in context why those, make sense for us to have incurred in this context as well.
Yeah. And I wouldn't revisit it here, except for this is the specific issue, and I just thinking about it, I understand that it was, furthered in response to some calculation that Office of Public Counsel is recommending, but again, Homestead and Moore filed, testimony ahead of any of OPC's recommendations, so I'm just trying to reconcile that. I think I would better understand if there was a disallowance and then later on, and, some kind of rebuttal or surrebuttal, they were
Sure, and I think, sorry, I didn't.
trying to just reconcile that in my mind.
Oh, sorry, I should let you finish your question, I'm sorry. No, I think the reason we filed their direct testimony, there's kind of a sequence of events that led up to that, and I do describe that somewhat in my surrebuttal testimony, but from the company's perspective, there was a strong signal in our most recent rate case from staff that this case should consider the prudence of the NSR situation, and that was said by staff in the context of testimony that had talked about the NSR permitting decisions as well. I mean, it didn't even really address the decision to retire. The staff testimony in that case was really talking about the NSR permitting decisions and said that the proper place, so I felt like we had been signaled that that would be an issue in this case.
Okay, so they said you should be prepared, signaled that you should be prepared to talk about it in this case or in a rate case?
In this case.
Is that in writing anywhere?
Yeah, absolutely. I've got a quote, I think, in my testimony. If not, we can certainly find it.
Okay, that'd be helpful.
Why don't we go off the record while Mr. Wells tries to find the quote?
Okay,
Let's go back on the record.
So in page 14 of my surrebuttal testimony, I provide, it's in the context of providing some history on this issue, and I'm referring to Claire Eubanks's rebuttal testimony in the ER 2022-0337 case. And the context of that testimony, as I mentioned, had been raising questions, and it didn't say that the company's decisions about permitting were imprudent, but it said the staff had concerns. And then Ms. Eubanks went on to say, Ameren, Missouri intends to seek securitization in a future case. It is staff's position that that case would be the most appropriate case for the commission to consider the prudency of Ameren, Missouri's decision-making and ultimate recovery of the stranded asset. And again, when we read that, the phrase, consider the prudency of Ameren, Missouri's decision-making was, Ms. Eubanks' testimony hadn't been about the retire decision. It had been about the NSR decision-making process leading up to that. So we felt on notice that this was, that there was going to be potential for prudence challenges of these costs in this case.
I'll definitely review that. I appreciate you pointing it out. In this case, though, Ms. Eubanks has said we want to assess that in a future rate case. So now I'll just have to, I appreciate the page reference, and I'll go back and take a look at that. Thank you.
Sure. Mm-hmm.
Mr. Wills,
Yes.
what would you say are the key differences between between Ameren and staff concerning upfront financing costs?
I really only provided testimony on this piece about the Homestead and Moore testimony. I'm not aware that there are other differences, but I don't know that that there may not be some small nuances that I haven't gotten as involved in that Mr. Lansford would have, but I don't think there are other significant differences on that.
Any recross based upon commission questions or bench questions? MIEC?
No
I'm sorry,
questions.
MECG.
No, thank you, Your Honor.
MIEC?
No, thank you.
Commission staff?
No, thank you, Judge.
Public counsel?
Thank you, no.
Any redirect from Ameren, Missouri?
I have no redirect, thank you.
Mr. Wills, thank you. You may step down.
Thank you.
I believe the next witness is staff's.
That is correct, Judge. Staff calls Mr. Keith Majors back to the stand.
Mr. Majors, please be seated. And I already swore you in today, correct?
Yes, sir.
Go ahead, staff.
Thank you, Judge. At this time, staff tenders Mr. Majors for cross-examination.
Any cross-examination from MIEC,
No questions, thank you.
MECG,
No, thank you, Your Honor.
Public Counsel,
No, thank you.
Ameren, Missouri.
Thank you. Good afternoon. Good morning. I said good morning yesterday when it was yesterday afternoon, so my time's off. Let me try that again. Good morning.
Good morning. It's Keith for the court reporter. Keith, Keith, Majors, MAJORS.
I want to talk about your recommendations related to the cost of the expert services of Mr. Homestead and Mr. Moore. So in the position statement and in your testimony, the recommendation was not to include, and I want to make sure I have both the reasons why. First, because you say the testimony was largely the same as what was filed in the rate case. And then second of all, that customers have already paid the expenses. Is that your testimony?
Yes, that's what's in my rebuttal, yes.
And have you read Mr. Will's rebuttal on this topic?
I have.
And you were deposed by Mr. Lowry on various topics, including this one.
I was.
Has your opinion on the appropriateness of the inclusion of these costs and upfront financing costs changed?
As I said in my deposition with the, I can't say that I at some point I was aware of Ms. Eubank's testimony. I don't necessarily disagree with her testimony in that case. But with that in mind, it probably wouldn't be completely fair to the company to completely exclude these costs. So I think a fair outcome would be how the costs are treated, how staff approaches what I would call rate case costs that are similar to rate case expenses in the rate case, and a 50-50 sharing of those costs would be a fair outcome for at least from staff's perspective. A 50-50 split of 50% would not be reflected in the securitization amount, and then 50% of the overall legal costs. So that would, I think you really wouldn't isolate just Moore and Homestead in that, if you did that. It was probably my oversight in the testimony. It would be witness Reed. He testified on the more of the prudence and how the commission is the prudent standard. I would also include the legal expenses if you're going to do a 50-50 split for Mr. Lowry and Mr. Long. I think that's and Whitworth was much smaller expense in comparison. So all those costs are really similar to rate case expenses. So if you're going to do a 50-50 split, I would throw those into the pool. So I think that's a fair outcome.
Okay. Before we address the 50-50 split, I just want to make sure we're on the same page as to what staff's position is on the inclusion of these costs at this point in time. Do you agree that it was a reasonable, a prudent decision for Ameren, Missouri to address prudence in its direct testimony in this case, including the costs of Homestead, Moore, and the attorneys, Whitworth, all the names you just mentioned? Is staff challenging whether any of that cost was necessary, or are you agreeing it was necessary and you just want to split it 50-50?
Well, there's a dichotomy there. It may be prudent for the company, this is my approach to rate case expense, it may be prudent for the company to obtain whatever witnesses it likes to put on for the commission, but is it reasonable to flow the entire amount of the cost through the ratepayers? I don't know that it would be reasonable for that.
You agree with me that's two separate questions?
Sure, yeah.
Okay, so let's start with the first question.
Right.
Was it reasonable for Ameren, Missouri to use Mr. Homestead, Mr. Moore, Mr. Whitworth, Mr. Long, Mr. Lowry to put forth the case it's put on? So for direct, so rebuttal, and hearing costs.
Well, I'm not going to replace my judgment with the companies, but I'm not going to say it's unreasonable for the company to incur those costs. I'll say that.
You're the only staff witness on this topic, correct?
Yes.
Okay, so staff is no longer arguing that Mr. Moore and Mr. Homestead costs are inappropriate to be included in the upfront financing cost. I understand we still have this level issue, but in terms of the costs themselves, you still believe that's appropriate for inclusion.
Can you repeat that? There's a lot in that. I'm sorry. Can you
Okay.
repeat that question?
We agreed there's two questions. One is, was it appropriate for Ameren, Missouri to, for example, use Moore and Homestead indirect?
Yes.
And you're saying that was appropriate?
I'm saying that it's not unreasonable. I'm not going to dictate to the company how they should litigate their case.
So you're not challenging that cost?
I'm not challenging whether or not it's prudent or reasonable to incur the cost.
Okay, fair.
Yeah.
And the same would be true for Mr. Long?
Right. I mean, they're all costs to litigate the company's positions and put on their case. I mean,
Right.
Right.
I'm just trying to make sure, because obviously your pre-filed testimony
Right.
says it was not appropriate, says that it was recovered in the rate case already, that it's the same issue. You no longer are making those arguments.
no, I think in light of what Ms. Eubanks said in testimony, I don't think it would be completely fair to exclude wholesale, home and
Homestead
Moore
and more.
Homestead.
Yeah.
Not Morstead and, yeah.
It's early in the morning and it's day 4, I get
Okay.
it. You keep using qualifiers like completely fair, so that's why I keep asking the question. I'm just making sure there's not any reservation of those arguments for staff's positions going forward.
No, I think our rebuttal position was exclude Moore and Homestead. I think a fair outcome, you could call it staff's position, is you can split these costs 50-50. 50% of those costs are included in the securitization. And I would say that we would want to get, I only have those costs through early April. I mean, we would want to get, the bulk of the costs are going to be incurred at litigation, right? You have all the witnesses here, travel expense, room and board, things like that. So you would want to capture all that, regardless of whether or not you split the cost. I mean,
And part of the argument you made in your testimony was that these costs had already been paid in the rate case.
they have.
And you acknowledge that's no longer true?
No, they were incurred in the rate case. It's the question of how exactly did staff put in a normalized level of rate case expense. And so, we discussed in my deposition, I think staff may have put in a case average. So, if you're going back that far, 5 Ameren cases, 3 Ameren cases, there's dozens of witnesses. You may not particularly, I mean, you would have to go back and see what exactly witnesses were in that case and what comprised the normalized level of rate case expense.
So in the rate case, do you know what 5 cases Ameren, Missouri used to make that average?
As I sit here today, I don't know specifically what 5 cases.
Okay, may I approach?
Yes, you may.
Set of documents I have to go through. Given that we have Okay, I have to ask someone if I gave them the set that says WKT copy on the front. I did not? Okay, I found it. Nope, I got it, thank you. All right, I gave you a set of documents. I don't know that we're going to go through all of them, but I only wanted to have to do that once. So did you find in that grouping Mitch Lansford's testimony direct from 0337, which is the rate case?
I have it.
I want you to turn to page 29.
I'm there. I'm there.
So lines 8 through 10. Would you read that, please? I'll give you a moment.
Oh. Yes. 8 through 10.
Mm-hmm.
Would you like me to read into the record?
That'd be great. Thank you.
O&M expenses are decreased in adjustment 32 by $136,000 to reflect the average rate review expenses incurred by the company in the last 5 general rate reviews and recovery of these costs over a 2-year period.
So in your opinion, when you read that sentence, does that mean there were costs for the 0337 case included in his 5-case average?
Not specific costs, but they would be like, well, you would call them like-kind costs incurred over the last 5 cases.
Specifically, Rush Island prudence was not an issue in the previous 5 cases.
That's correct.
There was not a witness such as Moore or Homestead who testified in those 5 cases.
That's correct.
So that level of cost wasn't in the 5-case average proposed by Ameren, Missouri, correct?
Those specific costs were not in the 5-case average.
And then the case was settled, correct?
That's my recollection, yes.
And it was a black box settlement?
Yes.
When I say black box settlement, can you define that, please?
So generally speaking, in a black box settlement, if the revenue requirement, the parties agree on some kind of revenue requirement increase, for example, or decrease, and what is and is not included in terms of the various position of the parties is not readily visible. And so if you had hypothetically a $50 million increase, that could be comprised of various levels of costs that are unknown specifically to either the reader or really any of the parties that were signers of the agreement.
And when you say it's not highly visible, what's included in it, Ameren, Missouri could believe a black box number represents items 1, 2, and 3, and staff could believe that it represents items 3, 4, 5, and 6,
That's correct.
right? Because it's just a number that settles the entire case.
That's correct.
So is it accurate to say that there may or may not be any of Homestead and Moore's cost in the previous revenue requirement in the black box settlement number?
It's not for absolute certain.
So it's fair to say that no, you don't know.
No, I don't know.
Okay. And I don't know. Now let's talk about your 50-50 proposal, which isn't in testimony anywhere, right?
It's not. It's something in response to Mr. Lowry's line of questioning in my deposition, which I don't have a copy of today, but I can certainly remember.
If we need it, I have a copy for you. So in a rate case, staff often makes a proposal to share rate case expense 50-50, right?
I think we've taken various positions on sharing, but for the last recent rate cases, yes, it's been a 50-50 split of some rate case expenses. There are rate case expenses that are not shared, of course, but it's not a blanket sharing.
Okay. Is there a statute that governs rate case expense?
No. Not specifically.
Is there a regulation that governs rate case expense?
No.
Is there a statute that governs the expenses that can be included in securitization?
Yes.
Do you have the securitization statute with you?
I wish I did. I do have it printed, not with me today, but
No worries, I have a copy for you.
I thought you might.
Yes, you may.
Do you all need copies?
Thank you.
Is that a copy of the securitization statute?
Yes.
I'd like you to look at 393, 1700.1, which is the definition section. 7 is energy transition costs.
Yes, I'm there.
See that? And then 8 defines financing costs. So first, energy transition costs include financing costs. Do you agree with that?
Yes.
And then 8 defines financing costs. And the language on 8 says financing costs include, and you see the word all of the following. Then I would like you to go to subpart C under 8.
Yes.
And it says any other cost related to issuing, supporting, there's a lot of language here. The third line down includes legal fees and consulting fees. And it's talking about the structuring costs and administrative costs and all of those types of things. And then at the very bottom, it says including costs related to obtaining the financing order. Do you see that?
Let me, if I may, just,
Sure.
Can I read section C?
Absolutely.
Okay. Okay, I've read that, and I believe the last sentence, would you like me to read it? And, well, not the last sentence, because I think the whole thing's one sentence, but, or other amounts or charges payable in connection with the bonds, including costs related to obtaining the financing order.
Would you agree with me that including costs related, that, first of all, would you agree with me the financing order is the order that will come out of this case, or part of the order that will come out of this case?
Yes,
And the costs related to obtaining the financing order are the costs we've incurred for this securitization case?
yes,
Does the statute contemplate any kind of sharing?
no, not that I'm aware of.
It just says includes all of these costs,
Yes,
which is different than the statutory scheme for rate cases or the regulatory scheme for rate cases.
oh, sure, absolutely.
Do you agree in a rate case you're balancing the commission is balancing lots of different interests?
Oh, yes,
Okay. Give me just a moment. I have no further cross, thank you.
Are there any commission questions? I hear none. Any recross from MIEC?
No questions, thank you.
MBCG?
No, thank you, Your Honor.
Public Counsel?
No, thank you.
I apologize, that didn't make any sense whatsoever. Since there were no questions, there should have been no recross. My apologies. Mr. Majors, you may step down.
Oh, we still got the chance for redirect.
Any redirect from staff? That makes a lot more sense, Mr. Pringle, thank you.
Just a little bit, Judge. Mr. Majors, could you just describe the policy reasons why staff takes that 50-50 approach in general rate cases for legal expenses?
Sure. Well, I think one, you said policy approach. I think it just varies utility to utility. I'll give the example, in days of past, utilities, for example, Liberty, then Empire, and Spire, then Laclede, they handled most of their legal expenses. Most of their rate cases were litigated through in-house counsel, and they had relatively minor rate case expense. But I think starting in the early part of the last decade, rate case expense really got the spotlight because there were a few cases where it was exceedingly high. And so I think the policy reasons why you would want to have some form of sharing, whether it's based on the requested rate case increase versus the actual ordered, or just a straight flat 50-50 split of those costs. One, it's an appropriate mechanism for sharing the benefits of the rate case process. Ratepayers get rates that are that will ensure the company has the opportunity to earn an authorized rate of return, and the company has an opportunity, rates that allow the company the opportunity to earn its authorized rate of return. And just from a policy perspective on what are rate case expenses, so it's the only sharing of expenses. All the commission expenses are paid through the assessment, so those are paid by ratepayers. Any intervener costs are paid through their individual interveners. And so with no kind of incentive or sharing mechanism for the company incurred expenses, the company would have no real impetus to hire any manner of witnesses or incur very large rate case expense. Now, so that it's somewhat of an incentive, but in my experience, it's really not been a harbinger for utilities to not incur rate case expense. The utilities are going to use their own discretion to execute and litigate the rate cases as they see fit. But I think I would draw the comparison, what I discussed earlier with Ms. Tatro. There are expenses that are, yes, they're prudently incurred from the company's perspective, but they're not necessarily reasonable to flow all those expenses through the cost of service to ratepayers. So I think that's a fair summation of staff's policy for sharing. And I would say, again, it's a case-by-case basis. I think there's an argument to be made that if there's not a lot of in-house counsel, in-house witnesses that can be obtained, then we would revisit the sharing recommendation. And it is done. It's not every rate case we say we're going to do 50-50 sharing. It's a case-by-case evaluation.
And then some of those, the reasoning you just described there regarding the general rate case expense, would that reasoning also apply to this case?
I do. I think that reasoning would apply. I mean, again, I'm not an attorney. I just read the statute. Let's say, we've all done hypotheticals. Let's say the company spent $5-6 million hiring 10 Nash Longs, and you can't duplicate Jim Lowry. There's only one Jim Lowry, so. But I'm not sure I'll take that, Judge. But say they spent $5-6 million. I mean, I don't think the statute would handcuff the commission to say we absolutely have to flow those costs through the securitization. I mean, where would exactly be the limit? I think I would rely on the, I don't know if, again, I'm not an attorney, I don't know if the prudently incurred wording, phrasing, that applies to the actual retirement. I don't know if that really applies to the financing costs, but certainly if there were imprudently incurred financing costs and legal costs, that I would suspect the commission would not want to include those in a securitization amount.
And then, when we were speaking about the last general rate case, were there any dollars to adjust regarding the securitization in that rate case?
I don't think there weren't any expenses for securitization in that rate case, no.
So for the most part, this would be the first time to deal with that.
Right. I think the dollars you're referencing are any kind of legal costs to my knowledge, there's no cost in the rate case that's related to this securitization.
Thank you, Mr. Majors. No further questions, Judge.
Mr. Majors, you may step down. At this point, I would like to, it is 10:21. We have an agenda at noon. So I would like to talk briefly about issue 15 because I believe there's an agreement there. So I'd like to kind of codify that agreement on the record. And then I think we'll take a short break. So issue 15 is the Department of Energy loan funds, and it says, should Ameren, Missouri issue the securitized utility tariff bond to the U.S. Department of Energy under the Energy Infrastructure Reinvestment Program, or issue the bonds in the customary manner to public investors? And that was a Renew Missouri issue. And if I remember right, and please feel free to correct me if I'm wrong, is that Renew's attorney, Mr. Linares, had indicated that the parties had all agreed to waive cross, to enter Mr. Owen's testimony into the record. He did want the commission, while he agreed it might not be appropriate in this case, he did want the commission to consider it and possibly mention it in order to keep it for a future case. Is my understanding correct?
I think you've got it exactly right, Judge. Jim Lowry, by the way.
Now, I cannot remember. I don't believe that I took the testimony into the record at that point.
No,
So
you did not.
they were assigned, Renew was assigned 300 through 349. Mr. Owens has, I believe, one piece of testimony, and that is the rebuttal testimony of James Owen. I would like to admit that onto the hearing record as Exhibit 300. Are there any objections? James Owens' rebuttal testimony, Exhibit 300, is admitted into the hearing record. At this time, as I indicated before, I'd like to take a recess until about, say, 10:35. And we are off the record. Now, we have agreed to do issues 16, allocation of the revenue requirement. How should the securitized utility revenue requirement be allocated to the customers? Issue 17, which has an A, B, C, and a D. Should the tariff sheet changes recommended by staff be adopted if securitization is authorized? Should the compliance tariff sheets, A, tie the voltage adjustment factors to the similar factors used in the company's fuel adjustment clause, B, include the name of the securitization charge on the customer bill be labeled, quote, Rush Island Plant Retirement Charge, end quote. C, require the rate be rounded to the nearest fifth decimal point. D, clarify the application of the SUTC, Securitized Utility Tariff Charge, in the event of a new or modified territorial agreement. And issue 20, does an Ameren, Missouri customer only have an obligation to pay Rush Island securitization charges that customer incurs when Ameren, Missouri is providing electric service to that customer? An example, are former Ameren, Missouri customers who are not served electricity by Ameren, Missouri obligated to continue to pay Rush Island securitization charges until Ameren, Missouri no longer collects Rush Island securitization charges? And if I remember right from the beginning, MIEC wanted to do a mini opening before this issue. Is that correct?
That is correct, Your Honor.
Could you lean in closer to the microphone? I apologize.
That's correct, Your Honor. I can come up to the podium or stay here, whichever is more convenient for you. Doesn't matter.
I will leave that to your preference.
Okay. I'll go ahead and stand up. Good morning, Your Honor. Good morning, Commissioner Kohlmeyer. My name is Diana Plesha. I represent the MIEC. The MIEC is supportive of Ameren's proposal to securitize costs in this case. The issue that we have is that Ameren's proposed cost recovery mechanism in relative kilowatt hours or energy consumption is unjust and unreasonable. Allocating these costs on an energy basis would unfairly increase rates to industrial customers without any basis in Ameren's cost. Ameren's proposal on allocation in the testimony of their witness, Stephen Wills, is a proposal that's based on commission decisions in the Evergy and Liberty securitization cases. Both of those cases involved Winter Storm Uri costs. These cases are entirely different than the present case. The Storm Uri costs were fuel-related costs in both cases. In fact, it would be entirely consistent with those cases for the Commission to allocate the Rush Island costs on an equal percentage of base revenues, just as other increases in non-fuel costs should be reflected in rates. While the Liberty securitization did involve costs from the closure of the Asbury plant, those were properly characterized as fuel and energy related, as distinguished from the costs in this case, which are demand related. The Asbury plant supplied the Southwest Power Pool SPP, and the costs involved were fuel and thus energy costs. And I would refer you to case number EO 2022-0040, page 88, where the Commission lays out the rationale for its order. And that rides on the SPP aspect. So they really are fuel costs, and there would be no inconsistency in finding that in the present case, the securitization costs are indeed demand costs. There is no inconsistency at all in these findings. So from the argument and perspective of Mr. Wills that Ameren's position was based on a need for consistency and following precedent, I would argue that the prior two cases would militate against finding the cost to be energy related in this particular case. And Ameren's witness, Mr. Wills, does acknowledge that that is the crux of the argument, and also recognizes that the MIEC's proposal through the testimony of Mr. Brubaker and Mr. Brubaker's proposed allocation is entirely appropriate. If you go to page 38 of Mr. Will's testimony, he states, The company's position is that both the cost allocation method that it proposed and the method proposed by MIEC witness Brubaker are within the Commission's authority to adopt. The company recommended its approach premised on driving consistency with the prior Commission's securitization decisions. The company would not have significant concerns, however, if the Commission was persuaded by MIEC's arguments and chose to allocate the cost on the basis of base rate revenues. Now, turning to staff's position, staff witness Lange proposes to allocate Rush Island securitization costs on an energy basis. As stated in the testimony of Mr. Brubaker, this proposal has no relationship at all to cost causation and is fundamentally unreasonable. Ameren has never proposed to allocate fixed cost on a class kilowatt hour basis, and the Commission has never supported such an allocation. All of the Rush Island costs to be securitized in this case have always been based on demand and not on energy. Accordingly, the cost of securitization should be allocated similarly to the way that those costs are allocated in rates. On a policy as well as an evidentiary basis, the Commission should ensure that securitization costs in this case should follow how these costs have been allocated as demand-related. The securitization costs are substantial, and if the Commission were to adopt staff's position, large customers would experience large and material rate increases from not only this case, but also future retirements of Sioux and Labradee and other plants. This will establish a precedent for Ameren's upcoming plant retirements, and the rate design that's chosen, the allocation that's chosen in this case, will have a material impact beyond just this case alone. Given this level of exposure and the potential departure from cost of service principles, it could be difficult for large energy-intensive manufacturers to move or expand to expand their facilities or move to Missouri. And I would refer you to testimony of Ameren's witness Robert Dixon in the Boomtown Solar Certificate of Convenience and Necessity case, where he makes the point, I think, perfectly well and is an expert in economic development. He stated in his testimony, he's asked to describe the benefits to the state of Missouri, the economic development benefits of Commission decisions that are based on economic development. And he states, economic development is an important customer affordability strategy, and it is included in Ameren, Missouri's annual business plan. By attracting new customers and helping our existing customers grow their operations here, we can expand our customer base and better utilize our infrastructure, including by spreading our fixed costs over the additional electricity sales economic development creates. This ultimately keeps rates lower than they would otherwise be for all other customers. It's important to note that large customers end up spreading out fixed costs, and they end up causing rates to be lower for other customers. So it's very important to preserve and protect and attract large, high-volume energy users over time. And not to mention the economic developments of the jobs and the multiplier effect from every manufacturing job, creating as many as 7 or 8 jobs for other sectors. The allocation of the cost in this case will be very important as large power users are looking at whether to locate here or expand, and it would be pivotal, the Commission's decision will be pivotal in determining and encouraging or discouraging whether industrials come to the state. That's all I have. Thank you.
Any questions from the Commission? I have none. Thank you for that mini opening. I'm just going to say, bear with me if I go a little slow through here. We're condensing 3 issues, which causes me to have to jump around, and much like juggling, I've always got one ball in the air in this case. So bear with me if we move a little slower. We have agreed for these 3 issues to take Ms. Mantle out of order since she has another obligation. So, OPC, you may call your witness.
Public Counsel calls Ms. Lena Mantle.
And I believe Ms. Mantle is only here for issue 17, is that correct?
Yes.
Would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you give at this evidentiary hearing today is the truth?
I do.
Thank you. Please be seated. OPC.
What is your name and would you please spell it?
My name is Lena Mantle, Lena, and my last name is Mantle.
Did you prepare written rebuttal testimony that's been pre-filed in this case and marked as Exhibit 211?
Yes.
Would you have any changes to that Exhibit 211 for it to be your testimony here today?
No.
With that, I offer Exhibit 211.
Any objection to admitting Exhibit 211 onto the hearing record, and that is the rebuttal testimony of Lena Mantle? I hear no objections. Exhibit 211 is admitted onto the hearing record.
I tender Ms. Mantle for examination.
Any cross-examination from MIEC?
No questions, thank you.
MECG?
Good morning, Ms. Mantle.
Good morning.
I guess for the record, this is Tim Opitz, counsel for MECG. Your testimony, at least your rebuttal, is focused on tariff issues. Is that correct?
Yes, it is.
And are you familiar with the disputes about the mechanism, how these securitized charges, if any, should be collected?
Only at a very high level.
Do you have an opinion about whether your concerns about the tariff language would be alleviated if the commission were to adopt Mr. Brubaker's proposed allocation method?
No, my concerns have nothing to do with it. It has more to do with the structure and the wording and the clarity of the tariffs as proposed.
So looking at issue 17, the issue A says tie the voltage adjustment factors to the similar factors used in the company's fuel adjustment clause. Do you understand that's an issue that you're testifying on?
Yes.
Mr. Brubaker's allocation method wouldn't implicate that issue, would it?
I don't believe so.
Issue B is include the name of the securitization charge on the customer bill, be labeled Rush Island Plant Retirement Charge. However it's allocated, would your position be that's what it should be called?
Yes.
So whether it's staff's method or the method proposed by Mr. Brubaker makes no difference on that issue?
No, the customers just need to know what they're paying for.
Issue C, or sub-issue C, says require the rate to be rounded to the nearest fifth decimal point. Would that be an issue under Mr. Brubaker's proposed method?
I don't know.
And on issue D, clarify the application of the SUTC in the event of a new or modified territorial agreement. Would that be implicated by the position advocated by Mr. Brubaker?
I don't know. I haven't thought that through.
Okay, that's all I have. Thank you, Your Honor.
Any cross-examination from the commission staff?
Very briefly, did you review Mr. Brubaker's testimony?
No.
So you don't recall if there were tariffs, or you wouldn't know if there were tariffs or not attached to that testimony?
That's correct.
And so you would not be able to answer if you would have different or additional concerns instead of the ones presented here today if Mr. Brubaker's tariff or allocation method was the one approved. Is that correct?
Can you start the
try to.
question over, please?
Without seeing a tariff, can you identify problems with it?
No.
I think I'll leave it at that. Thank you.
I'm sorry, Judge. I don't know who that is speaking.
I apologize. It's Nicole Mers, MERS, for commission staff.
Ms. Brewer, thank you very much for stopping us. Any cross-examination from Ameren, Missouri?
Jim Lowry, no, Your Honor, thank you.
Any redirect, or I'm sorry, any commission questions?
No questions, Judge.
Any redirect from public counsel?
No, thank you.
Thank you, Ms. Mantle. You may step down and you may be excused.
Thank you, Judge.
I would like for the, it looks like we have tremendous overlap of testimony, so I'd like to, in order with this, start with Ameren, then go to staff, and then finally MIEC, and that appears to comport for the most part with the way it's set up. So with that, Ameren, Missouri, will you call your witness?
Call Steve Wills back to the stand.
I'll remind you, you're still under oath, and please have a seat.
Judge, and this will be the last time Mr. Wills takes the stand, and so I'd like to, at this time, offer Exhibits 19 and 20.
Any objections to admitting Exhibits 19 and 20 onto the hearing record? And those are the direct testimony of Stephen Wills and the sur rebuttal testimony of Stephen Wills.
Judge, public counsel objects to Schedule SMW-S1, which I believe is a schedule to Mr. Will's rebuttal testimony on the basis that it's hearsay.
Hold on a second while I pull it up, please. Let's go off the record for a moment. You said sur rebuttal, correct?
Correct.
Back on the record. Mr. Williams, would you explain your objection to me?
Sure, it's hearsay in that it's a letter from Dr. David Hogg, who is not present and is not a witness in this proceeding. There's no opportunity to cross-examine him or verify anything that's included in this exhibit to verify it. It's clearly hearsay.
What evidentiary value do you think this has?
I'm not sure of what evidentiary value Ameren, Missouri thinks it may have, but there are statements in here about impacts on the school district and how the quantifications of those impacts matters that there's no opportunity to examine anyone about.
Obviously, Judge, I'd like to be heard when it's convenient.
I think it's convenient right now, Mr. Lowry.
So, and Judge, if necessary, I'd be happy to void hire the witness on the basis of his opinions. But again, Mr. Wills, by definition, is appearing here as an expert witness. He's a senior director of regulatory affairs for the company. He has testimony on policy matters related to the community transition costs, which is actually where this issue came up, I'm sure. And he is entitled under 490.065 to rely on hearsay as long as that hearsay is reasonably reliable and it's the type of information that would be relied upon for giving the kinds of opinions he's giving. And I think Mr. Wills, we can certainly establish that that's the case. So it doesn't mean it comes in for the truth, but it comes in to explain the basis of opinion under that statute.
Mr. Williams, you have a response to that?
As long as it's being used to, as a basis for formulating some opinion, but I don't know what opinion that might be.
Well, he's given those opinions in his testimony, actually, so.
I'm going to let it in with the limitation that it is being brought in for the basis of his opinion and not for the truth of the matter asserted in the schedule. And it wasn't separately numbered, so I see no reason to do that. That's just a notation.
No, it's a scheduled as testimony, so it would just come in with the exhibit, yes, or with the testimony, Judge.
And with that limitation.
Yes, I understand.
Okay, to that extent, the objection from public counsel is overruled. Go ahead. Well, actually, I guess it's my turn. You had indicated if there were objections. Are there any further objections? I hear none. The Exhibit 19, the direct testimony of Mr. Wills, is admitted onto the hearing record, and Exhibit 20C and 20P are admitted onto the hearing record with the limitation I just voiced.
And with that, Judge, I tender Mr. Wills for cross-examination.
And just for a little clarity, Mr. Wills is here, I believe, on all three of these. Is that correct?
That is correct.
Okay. Any questions from MECG?
Yes, Your Honor. For the court reporter, this is Tim Opitz for MECG. Good morning, Mr. Wills. Starting with the allocation method, do you agree that the costs to be securitized are fixed in nature?
Yes, I do.
And would you agree that fixed costs aren't normally recovered through an energy-only allocation?
Generally, yes. I don't know that I could say exclusively yes, but generally, yes.
How about the fixed cost of this nature, i.e. related to a coal generation unit? Would those be allocated on a energy-only basis?
Can I clarify, when you're talking about allocated, are you talking about allocated between classes, or, rate design itself in some way allocates costs between customers' bills? So I think there might be a distinction in my answer on that.
I guess let me clarify. So when costs related to a coal plant are recovered, would you agree that some of those costs are recovered through a demand charge, some are recovered through a energy charge, and some are recovered maybe through a customer charge?
So I guess there's the theoretical world, and then there's what practically has happened. I don't think we oftentimes get orders necessarily that make that crystal clear what costs are allocated to which charges. But in terms of the conceptual approach we take to designing rates, I would agree with that. I don't know that there would be any costs. I guess with the caveat that I don't know that there would be any cost of a coal plant allocated to a customer charge ever under our at least any approach Ameren, Missouri has ever taken to rate design.
Okay. Let me jump forward. So you understand Mr. Brubaker has proposed a alternative recovery method compared to what you offered in your direct testimony, right?
I do.
And his method would recover the securitized amount through a uniform percent charge applied to the base components of a customer bill. Is that right?
That's my recollection and understanding, yes.
If the commission ordered the company to implement Mr. Brubaker's recommendation, would Ameren be able to implement that?
Yes, I believe we would.
And if the commission ordered Mr. Brubaker's allocation method, would Ameren still be able to issue the bonds in the market related to this cost?
I'm not aware of any reason we wouldn't be able to. No.
I guess turning to the tariff issues, which I think is issue 17. If the commission were to order Mr. Brubaker's recovery method or allocation method, would do you have an opinion on how that would impact these tariff issues as presented to the commission here?
The issues that are listed for decision here?
Yes.
Yes, I think that it would change the kind of what I would recommend they find on the issue of the FAC voltage factor issue. I don't think if Mr. Brubaker's method were approved, there's no loss adjustment involved in that methodology, so having voltage adjustment factors would not be needed. In
So the commission wouldn't need to make a finding on that issue?
That's my opinion, yes.
Would they need to make a finding on the issue of, well, I guess, they would need to make a finding on the issue of what to name the charge on customers' bills regardless of the method chosen, correct?
Yes, although I think that finding could be to also not name the charge, but they would need to resolve that issue in some way, shape, or form.
Would the commission need to make a finding about the rate being rounded to the nearest fifth decimal point?
Yes, that issue would have to be resolved.
And would the issue, I guess just for completeness, related to the territorial agreement, whether the charge would apply to customers in that event, would that still be an issue?
Yes, I think that's unimpacted by the cost allocation method.
So I guess at least we can say that there's at least one issue that would be not up for commission resolution if the commission were to choose Mr. Brubaker's allocation, and the other ones would not be impacted. Is that right?
Yes, that's my opinion on those, yeah.
Okay, that's all I have. Thank you, Your Honor.
Any cross-examination from MIEC?
Yes, good morning, Mr. Wells.
Good morning.
I'll try again. So referring to your direct testimony on the bottom of page 5,
Yes, I'm there.
is it correct that the energy-based collection of securitization costs that you put forth in your direct testimony was chosen to mirror the recovery method from the recently concluded Liberty securitization case and the recently concluded Evergy securitization case?
Yes.
Do you agree that all of the costs in the Evergy case are variable costs related to Winter Storm Uri that otherwise would be collected through the fuel adjustment clause?
Yes, although I think it's also conceivable that they could be put through some other sort of deferral mechanism due to the extraordinary nature of them, but absent some other treatment, like a deferral for an extraordinary event, it would go through the fuel adjustment clause.
Okay. And in terms of the Evergy case, could you take a look at page 8 of the rebuttal testimony of Morris Brubaker
I don't have a copy of his testimony with me up here.
for you? Judge, can I provide the witness with a copy of Mr. Brubaker's testimony?
Yes, you may.
Okay, so if you look at page 8, do you agree that Mr. Brubaker has accurately excerpted the commission's order that winter storm costs, Uri costs would otherwise have been recovered through the fuel adjustment clause?
Are you talking about the ordered paragraph 144 in the middle of page 8? Is that what you're?
Correct.
Yeah, I mean, to my recollection, I believe he's properly cited that. I've read the order. I didn't read it this morning to go word for word here on a comparison, but I believe that that's properly cited, yes.
Okay, and if you look at page 8 and also turning to page 9 of Mr. Brubaker's rebuttal, do you agree that Mr. Brubaker has correctly assessed the cost to be recovered in the Empire Liberty case, that 71% of the total costs were costs that would have been recovered through the fuel adjustment clause, and the balance of 29% related to the closing of the Asbury plant were expected to benefit customers through decreased net cost of participation in the Southwest Power Pool that would flow through the fuel adjustment clause to them?
I mean, I haven't done the math to verify the 71%. Those sound like accurate characterizations of what's in, the page 8 ordered paragraph there. I haven't, done the division to come up with the percentages.
But you would accept that subject to check?
Yes.
Okay. And in contrast to these two cases, is it true that in the case of Rush Island securitization, that the costs in question that are to be securitized are not fuel-related costs, but are fixed costs?
Yeah, I think that's in contrast entirely to the Evergy case, but only, the percentage that you just, there was 29%, I suppose, taking Mr. Brubaker's number subject to check, that were similar to the cost of Rush Island. I consider the Asbury cost to be similar in nature, but not the Winter Storm Uri cost to be similar in nature.
Are the fixed costs not collected through the fuel adjustment clause? The fixed costs are not collected through the fuel adjustment clause, is that correct?
That's correct.
Okay, and whenever Ameren, Missouri has performed a class cost of service study, is it true, to your knowledge, that those costs have been treated as demand-related and allocated among customer classes as a fixed cost?
Yeah, the specific allocation that we've generally used for production demand-related costs is an average and excess method, which is it has a hybrid of demand and energy included in it, but it's generally classified as a demand allocator.
Okay. And could you please refer to your sole rebuttal testimony at page 18?
Give me a moment, please.
Sure.
Okay, I'm there.
Okay. At the bottom of the page, do you agree with Mr. Brubaker's assessment that the nature of the costs being securitized do not vary with KDPH consumption?
Yes.
And on page 19, do you indicate that Mr. Brubaker's proposed allocation approach, which includes an equal percentage of base rates for all customers, would be a reasonable alternative?
Yes, that's what I said there.
Okay. But then on page 19, you go on to state that an allocation on base rate revenues was rejected in the Liberty case. Do you see that?
Let me read the specific wording there. You're saying this is on page 19?
Correct.
I'm not sure I see the precise statement. Can you repeat the question again?
Sure. The question is, on page 19, you state that an allocation on base rate revenues was rejected in the Liberty case. And I'll direct you to lines 3 through 5.
Well, the distinction I'm drawing here is that I don't think the Liberty proposal was allocated, well, it was allocated to classes on base rate revenues. It wasn't allocated to individual customers. So I guess that is, yeah. So I didn't specifically say they rejected an allocation of base rate revenues, but that is underlying the class allocation in Liberties. And yes, I do say that the commission rejected that. So I'm sorry, I just wanted to be a little precise about it.
Okay, and just another question on that same page, if you go to lines 19 through 18, I believe, tell me if this is correct, but you're saying the commission's rationale for choosing loss-adjusted energy cost was expressed with respect to why it was just and reasonable for recovery of the Asbury retirement costs. Is that correct?
Yes, there was a paragraph that if I recall correctly, that the commission indicated that this allocation method was appropriate also for the Asbury costs, as I recall.
Okay, isn't it true that what was rejected in the Liberty case was a proposal to allocate variable costs on the basis of base rate revenues, the opposite of the situation here?
Could you repeat your question, please?
Sure. Isn't it true that what was rejected in the Liberty case by the commission was a proposal to allocate variable costs on the basis of base rate revenues? That is the opposite of the situation here. Do you agree?
I'm thinking about that. I'm sorry.
Sure.
I mean, I don't know that was. I think that that's a way you could view that order. I don't know how the commission weighed the amount of variable costs versus the amount of fixed costs and how they picked one method over the other. I don't think I have perfect insight into whether they were, but I think someone could interpret it that way.
So do you agree that the Liberty case opinion by the commission, the order, rejected a proposal to allocate variable costs on the basis of base rate revenues.
So it rejected a proposal, and that proposal would have allocated, is that, you're
Would have
following?
allocated variable costs on the basis of base rate revenues. Do you agree?
Yes, I think I do.
Okay. Are you familiar with Ameren, Missouri's response to staff data request number 26, which addresses the programming time to modify the billing system for collections from customers based either on a KWH charge or a percentage charge?
Yes, I recall. I recall, I didn't know the DR number off the top of my head, but I do recall that DR.
Would you agree that the estimated programming hours for either approach are roughly the same?
Reasonably similar. I think, if I recall correctly, it was a little bit higher on the percent of base rate revenue. And when I say a little, about 1,000 hours of programming relative to, about a 10 or 11,000 hour programming effort. So similar.
Would you accept, subject to check, that the KWH estimate is 11,162 hours and your estimate is 12,338 hours?
Those are definitely the right order of magnitude, and subject to check, I think those might be the exact numbers.
Okay. Is it correct that whether a per KWH or a percentage collection approach from customers is applied, that amounts will be collected monthly from customers and then paid to the bond servicing agent twice a year?
Yes, I believe so.
Okay. And would the mechanics of collection and submission to the bond servicing agent be materially the same regardless of whether collections from customers are on a KWH basis or on a percentage of revenue basis?
So could you repeat the question one more time?
Sure. Would the mechanics of collection and submission to the bond servicing agent be materially the same regardless of whether collections from customers are on a KWH basis or on a percentage of revenue basis?
I think the mechanics would be, yes, I do think so.
Okay. Would the process that Ameren, Missouri would employ to conduct true-ups, reconciliations, and other adjustments be similar regardless of which method of collection is used?
I believe so.
Are gross receipts taxes the gross receipt taxes in each municipality charged monthly on customer bills as a uniform percentage charge?
Yes, and within each different county or municipality or taxing jurisdiction, they have a uniform percent that is applied to customer bills within that.
Okay. And what is the approximate range of percentage charges among the various municipalities?
Just going off the top of my head, I would say probably 3 to 5, something like that, in that order of magnitude.
Okay, but it's fair to say then that within any given municipality, the percentage is the same for all customers in that municipality. Is that correct?
There may be instances where there's differences between residential or non-residential, but I would have to check that to be sure. I think I recall there may be some differences in the taxing on different residential versus non-residential, but within those groupings, then yes, it's uniform.
Okay. And is it Ameren, Missouri's expectation that the securitization payments from Ameren, Missouri will occur 2 times a year and be in roughly equal amounts?
I'm not the expert on the bond process, so that is my understanding, but I wouldn't want to, represent that I'm the expert and that I have 100% certainty of the timing.
Well, if I can refer you to staff's DR 25, subject to check, would you agree that if that DR follows that approach, would you agree, subject to check, that that's correct?
I would, if
Based on
Ameren,
it.
Missouri answered the DR saying that, then I would not have any question about that. That is the best information that we have.
Okay, that's fine, thank you. Let's see. Okay, no further questions, thank you.
Any cross-examination from the commission staff?
Good morning.
Good morning.
You have performed class cost of service studies for Ameren in the past, correct?
I've supervised those who have, yes.
Would you agree that the calculation of an allocation of an average demand for customer classes would be identical in result to a calculation of an allocation of loss-adjusted energy, assuming the same loss factors were used?
If the definition of the average demand were the average of all hours of the year, I would.
Is that what you would refer, when you use the term average demand, is that how you would refer to it or calculate it?
I don't know that we generally refer to the term average demand in our class cost of service. Maybe I'm.
What about average and excess?
So the average in excess does incorporate an energy value, but the demands themselves are what we call a 4 NCP, 4 non-coincident peak. So it's averaged for 4 hours of the year. But then the other component of that allocator is energy for the entire for the year. So there's an energy component and a demand component. That demand component is not equivalent to energy. It's not it's not all hours of the year in the average. So hopefully that clarifies.
In an average and excess allocation of production capacity, in your experience, is a percentage of production rate base equal to the system load factor allocated on the average demand? Or on energy?
It is. I'm trying to recall whether so the general premise that you've got there is correct. It's been a minute since I've looked at the calculation. So the demand component is weighted by one factor, and the energy component is weighted by the other factor, and one of them is the system load factor, as you've said, and the other is the inverse of it, the one minus that. I probably, to say absolutely definitively which is which, I would probably need to review a work paper.
Do you recall methods of allocations that other parties have used for class cost of service in the past?
I'm sure I recall some, yeah.
Do you recall staff's base, intermediate, and peak method? I think we called it the BIP.
I do recall the BIP.
The BIP. Do you recall if in that method, if all capital costs for base load units were allocated to classes on average demand? Or energy, if you prefer that term?
Again, that's another one where it's been a minute since I've looked at it. I don't know that I could definitively say that, but I don't know that I would dispute that either.
So subject to check, you would agree?
Certainly subject to check. If I could check it, I would agree.
I think we have testimony in prior cases that we could, actually, okay. May I approach?
Yes, you may.
You recognize that as a class cost of service report. I believe it's from 2016 case, but generally speaking, kind of, you've
Yes.
seen them before.
This looks familiar to me, yes.
And is that, they are very large, as you know, so that's just the general introductory section. Now, I believe if you would refresh your memory on pages 8 and 9.
8 and 9, did you say?
Yeah, I believe so. There should be a section that talks about how staff has, how staff's BIP method works.
I'm sorry, maybe I'm scanning too quickly. If you, as far as on 8 and 9, I'm looking for.
It's not all in there. I apologize for that, and I won't waste anybody's time before going back up to print the rest. Can you recall if Rush Island was characterized as baseload in staff class cost of service studies in the past, particularly the BIP?
I can't imagine that it wouldn't have been.
And do you recall that Ameren, Missouri's system load factor at the time of its last general rate case was over 50%?
I'm generally familiar with the number, and I'm sure it was. I don't remember a specific number from the last rate case, but.
And so you said you're generally familiar with some of the methods staff has proposed in the past. Are you generally familiar with some of the methods that Mr. Brubaker has proposed in the past?
Yes, I think so.
Are you aware of a case in which Mr. Brubaker did not recommend reliance on some form of an average and excess study in which loss-adjusted energy sales would have been the basis of allocation for a majority of the production capacity rate base?
I don't know about the majority, again, because I needed to check whether the load factor or the one minus the load factor was on the energy piece of it. You know, I think Mr. Brubaker's been testifying for quite a while, and I seem to have some recollection that I may have seen some past testimony where he may have used just a 1 CP or some other things. I couldn't point to a specific case, so I'm not sure that that's the exclusive method that I've seen him use, but I can't point from case to case on exactly what he's done.
So we don't want to, I won't hold you to it, but so then would you say, at least in general in your experience, that it seemed to be the average and excess study with the loss-adjusted energy sales?
In the most recent Ameren, Missouri rate cases, I think that he's advocated for the average and excess method, which again is a hybrid of, I could think of it as a hybrid of a demand and energy allocator, but definitely is also classified as a production demand allocator.
Were you here for the beginning of the hearing?
Yes, I've been here for, I mean, it depends on precisely when you said. I've been here for most of it, yeah.
Did you hear the testimony of Ameren's witness, Katrina Niehaus?
Yes, I think I was in the room.
And do you recall her cautioning in response to a proposal from OPC about removing or lessening confidentiality provisions from bond letters, that the bond community was very skittish over changes to anything in the securitization process?
Yeah, I mean, I remember the topic.
And do you recall her also stating that Missouri's process was already known and becoming familiar to the bond community because it's our third time around, the commission's third time around? Do you recall that?
I think there was some discussion of that sounds about right.
And the allocation method proposed by staff's witness Sarah Lange in the rebuttal testimony is consistent with both of those cases, the past two securitization cases, correct?
It is.
And do you recall, or is it correct that those cases survived judicial review, to your knowledge?
I can't remember. Certainly the Liberty case did. Evergy may have as well, but my memory is failing me to be certain on that at the moment.
Have you seen a tariff from Mr. Brubaker?
No, I haven't.
So you couldn't say if that tariff would raise different issues? that would cause concern for Ameren or another party?
I mean, I think we would certainly have to draft new things that haven't been drafted yet. I don't know that I see that as an intractable problem, but it would have to be done.
When would that have to be done?
Well, I think we would have to, it would have to be done between the time that we got a commission order authorizing, a particular method. And then we would have to file compliance tariffs. I know, as far as actually, I think there's a number of different paths that could go on. I'm trying to think about how that would necessarily play out. I know the final tariffs that will show the charges have to be filed, at the time that the bonds are issued, and then there's a 4-day period for those to be approved at the time the bond is issued. I think you could take the general tariff language and get an approval or an agreement of that in advance of that, but the final tariffs are in a tight window around the bond issuance.
And you've talked a little bit about Liberty's case. In your recollection, did the commission distinguish in that case how to allocate storm costs versus retirement costs?
I mean, I think it had paragraphs that as I recall, that separately addressed each issue and found both of them were reasonable to be allocated in the manner that they were.
Hopefully this is pretty quick, but just for clarification, you had some questions where you were talking about the kind of charges on a bill, where fixed costs go, where variable costs go. What would you consider base components of a bill?
I would consider base component. So we have a tariff rate schedule for our service classifications, and I think those that are contained within each of those, like for example, our residential is a 1M tariff. I think all of the charges that are contained within the tariff sheets of the 1M would be the base charges for a residential customer, and similarly for our other customer classes. They generally are a customer charge, a fixed monthly customer charge. Some classes may or may not have a demand charge, and then a variety of energy charges that might be blocked, might be time of use, might be flat. But essentially the broad categories are the customer charge, the demand charge, and the energy charge. There are additionals like the reactive demand charge for some of our larger customer classes is a base, I would consider a base tariff charge, but I would view those as the ones that are kind of contained within the four corners of the tariff sheets for the base service classifications.
So where would something like Rider B fall in?
Yeah, Rider B is an interesting one. It doesn't fall within the four corners of that, although I'm sure there's a reference to Rider B, but the charges are on a separate rider. I think that I would probably not consider it a base charge there, but that could be something that could be determined. I guess if someone wanted to argue for that to be a base charge, it could be, you could argue that.
If somebody had wanted to raise that argument, where would that occur for processing how the securitization components?
Can you speak a little more into the mic, please?
Apologize. If a party had an issue with the base components as it dictates what parts of the securitization or how the securitization charge is allocated, with the Rider B, Rider C, when would that debate or hearing happen?
I don't know. It depends on when someone identified that issue to challenge it.
And just to clarify, are there any parties that are disputing the FAC loss factor issues?
Not to my knowledge.
And Ameren, Missouri participates in MISO, correct?
Yes.
You were asked, you had a conversation with Ms. Pleshy about SPP. Do you recall that?
But I don't recall that.
It was, it regarded the order from one of the securitization cases, Liberty's securitization case, about how the interaction of SPP impacted the allocation methods.
I don't know that SPP in particular came up in that conversation that I recall, but if you're saying that SPP is referenced in the order, then that may be the case. But.
Would you say that MISO and SPP are different, or are they similar enough that they could be interchanged in these?
I mean, it depends. It really depends on the guy. Certainly, there are differences. I mean, there's no question. I think whether you can interchange them depends on what you're asking that about. I mean.
Do the nature of the securitization cost vary? The nature of the cost being securitized, do they vary at all?
The nature of the cost being securitized, do they vary from each other? Is that what you're saying? Or from what? Vary?
Okay. I'm going to wrap up, but do you recall mentioning, I think it was staff DR 26, where you your memory was refreshed that Ameren's expectation was 2 bond payments, equal bond payments. Does that sound correct?
I think that might have been 26. I thought was, maybe I'm misremembering, but I thought 26 was the one that had the estimate of time to program the charges. But maybe I'm misremembering.
You may have the better memory than me today. So, but do you recall that discussion?
Yes.
That DR.
Yes.
And are you familiar with the rebuttal testimony of Ms. Sarah Lange?
Yeah, I've read it.
And are you familiar with the charts that she has on page 7 of her rebuttal and page 5 of her rebuttal that show the volatility of the payments under MIEC's allocation?
I have a general recollection of those charts. Yeah. I think I do. I mean, I think I know which ones you're talking about. But
do you recall them not being even?
yes.
Okay. That's all I have. Thank you.
Any cross-examination from public counsel?
Thank you, no.
Are there any commission questions? What is Ameren's currently approved allocation method for rates from its last rate case?
So in the last rate case, I don't know that there was a commission order on the allocation method. Ultimately, what was approved, I'm trying to remember if there was any class shift. There ended up being a class shift at the end because we had a industrial rate cap issue. But otherwise, and there might have been a small shift between 2 lighting classes. I might be confusing the 2022 case with the 2021 case there. But in general, I think that there was an equal percentage increase of all classes and all rate elements in that case, subject to maybe a couple of minor details that might have been slightly different.
I think I was going a little broader there. I mean, would you say it's a demand allocation? Would you say it's a energy allocation? How would you describe the allocation?
I mean, so there's are different positions from different parties in the case, and I don't know that those issues were specifically resolved by a commission order. I would say every party had some amount of demand allocation, some amount of energy allocation, and some amount of customer allocation. The magnitude of which costs were allocated according to those different metrics would have varied across the different parties, but all parties would have I think had some amount of demand, energy, and customer allocations that occurred. And I think what's implicitly underlying our rates most certainly has some, underlying allocation to those 3 categories. But as far as can you draw a line from a commission order to decipher what's in our rates, what was allocated versus which, I don't think you can really do that.
Okay. Well, let me ask this. Assuming things with the current rate allocation stay as they are and out into the future, in addition to the anticipated true-ups required for securitization, or standard true-ups, if MIEC's method were adopted, would an additional true-up be required after a rate case?
Let me just think just for a second. No, I don't think it would. I'd have to think, I mean, I may need to think through the mechanics just a little bit, but it doesn't seem immediately obvious to me that there would be an additional. Because so what you would have to put in the tariff, I think, is you would have to put in what are the base rate, so Mr. Brubaker is proposing a % of base rate revenues. To apply that, you have to know what the base rate revenues from the most recent general rate case were. So I think you would probably need to update, and again, I'm just thinking about this on the fly. I think you would probably need in each rate case to update in the securitization tariff what the base rate revenues are. But yeah, I think that's what you would do. That's, at least as I can think about it sitting right here without sitting down at a tariff and sketching it all out, I think you would want to just have the tariff state what the base rate revenues are so that you can calculate that percentage, and you would have to update that with each rate case.
Thank you. That was very helpful.
You're welcome.
Any recross? MECG?
No, thank you, Your Honor.
MIEC? Staff? Public counsel?
No, thank you.
Any redirect from Ameren, Missouri?
I think just maybe one question, but certainly one topic. Ms. Mers asked you, I think, about sort of how she asked you, she pointed out that Mr. Brubaker's not proposed a specific tariff, and then you answered and said we would have to have a tariff, and there was some discussion about timing. Do you remember that?
Yes.
And I think what you were saying was, look, we would have to have the tariff terms before we could start making charges. But because, there's probably going to be at least months between when the order comes out and when charges actually happen, it was doable to do that. Presumably, there would be time to figure that out. Is that more or less what you were trying to convey?
Yeah, I think so. I mean, we always, out of any case, you have to have compliance tariffs with the commission's order, and there's some amount of time. Oftentimes in rate reviews, there's a very short window. I think in this case, you'd have a little bit more window to get those compliance tariffs, filed and approved.
I mean, ultimately, if there was disagreement, the commission would have to resolve the disagreement, right?
I would think so, yeah.
But there is some time. Is really the only point you were making? Is that right?
I think that's fair.
Okay. Thank you, Judge.
It is now 11:41. There is a noon agenda today, and I have pushed everybody pretty hard to try and stay on schedule, and we seem to have done that. I'm going to propose that we break from now until about 1 o'clock to give people an opportunity to give the commissioners an opportunity to go to agenda, and to give everyone else an opportunity to have lunch. Is there anything I need to take up before we recess? Okay, we are, we will break until 1 o'clock, and let's go off the record. Thank you. believe we had left off, we had just finished the testimony of Stephen Wills on issues 16, 17, and 20. A brief matter I want to take up just because I'd rather know sooner than later. I believe OPC and Ameren had proposed on issue 19 waiving cross on that issue. And I wanted to query the parties and see how they felt about that. Is there anybody who would be opposed to waiving cross on 19 and submitting that one on the testimony, obviously subject to the motions to strike? I hear no objections, and that is the amount to be securitized. Are there any commission questions on that issue, number 19, the amount to be securitized? And just to read it shortly, after the resolution of other issues listed herein, what amounts should the commission authorize Ameren, Missouri to finance using securitized utility tariff bonds? A, what total amounts of energy transition costs should the commission authorize Ameren, Missouri to finance for Rush Island? And B, what total amounts of upfront financing costs should the commission authorize Ameren, Missouri to finance? And that makes a lot of sense because really it's the decisions on the other issues that I guess largely determine that. So are there any commission questions on that subject? I have no questions on that subject. So when we get to number 19, I will again query and we can move on. Ms. Plescia, you had indicated that you had texted Mr. Kaufman earlier. Is that correct?
That is correct.
Would you mind asking him if he is okay with doing that? I certainly don't want to step on the rights of, or the due process rights of AARP or Consumer Council of Missouri.
Yes, I'll do that right away.
Okay. Well, there's no great rush. I intend to go ahead with the, well, I'll wait a second. Let's go off the record momentarily. Back on the record, please. Ameren, Missouri, you may call your next witness.
Actually, we don't have any more on this issue. I think staff is up next, based on what you said this morning.
I misread. Thank you very much. I was looking at a different issue. Okay, staff, call your first witness.
Staff calls Sarah Lange to the stand.
Ms. Lange, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing today is the truth?
I do.
Please be seated. Go ahead, staff.
Can you please state and spell your name for the record?
Sarah Lange, Sarah Lange.
And who are you employed by and in what capacity?
I am employed by the Missouri Public Service Commission. I am an economist on the staff of the Missouri Public Service Commission.
And did you prepare or cause to be prepared in this case rebuttal testimony that has been marked as Exhibit 106 and surrebuttal testimony that has been pre-marked as Exhibit 107?
I did.
And do you have any corrections to that testimony?
Yes. On my rebuttal testimony, it has come to my attention that schedules are labeled with a D instead of an R. Also in my rebuttal testimony, page 14, schedules are referenced as SLKS instead of SLKL. And it's come to my attention that the public version of my rebuttal testimony has the wrong case number and is denominated direct testimony on the cover, although the remainder of that document and its time of filing and such indicate that it is rebuttal.
Okay. And did you have any for surrebuttal?
no corrections to Sir rebuttal that I'm aware of.
Okay. And with those corrections in mind, if I asked you the questions within your testimony, would your answers be the same?
They would.
And are those answers true to the best of your knowledge and belief?
Yes.
I will go ahead and I can move this because this is her first and only appearance on the stand. So I would ask for Exhibit 106, the rebuttal testimony of Sarah Lange, and Exhibit 107, the surrebuttal testimony of Sarah Lange, to be admitted.
Are there any objections to admitting Exhibits 106, the rebuttal testimony of Ms. Lange, and 107, the surrebuttal testimony of Ms. Lange, onto the hearing record? I hear and see no objections. Exhibit 106 and 107 are admitted onto the hearing record.
I tender the witness for cross.
Any questions for this witness from MIEC? Any questions from for this witness from MECG?
Yes, Your Honor. Good afternoon, Ms. Lange.
Good afternoon.
In your surrebuttal testimony, you raised the issue of the timing of payments. Would you agree with that? Timing of the bond payments?
That is a subject in my surrebuttal testimony.
And would you agree that the gist of your testimony is that you believe the allocation method proposed by Mr. Brubaker would create certain issues with that payment? Is that correct?
I wouldn't phrase it that way. I think you could revise Mr. Brubaker's allocation method to provide somewhat more stability in the bond payment issue, but then you have introduced a volatility issue into Mr. Brubaker's allocation method. So you get to pick your problem, I guess is what I would say.
Now, regardless of whether the commission adopts Mr. Brubaker's recovery mechanism or staff's proposed recovery mechanism, would you agree that there's still going to have to be some aggregation of those payments made to Ameren, Missouri before it's paid to the bondholder?
I don't know what aggregation means in the question you just asked.
When Ameren, these securitized charges are going to appear on Ameren customer bills, is that right?
Yes.
And so Ameren will be the one collecting that money, right?
I am not certain of that, to the extent that something is done directly by Ameren versus being done by the bond servicing company. I would not be able to answer that question sitting here today.
Okay, so you don't know the mechanics of how that money gets from the customer who's paying their utility bill into the bondholder's hands?
Sitting here today, that is not entirely clear to me at what point those funds change hands. And whose hands are involved in the process from a legal standpoint.
But it's fair to say that however that process works out, there would still be some process either under your, I won't say your, staff's proposed approach versus Mr. Brubaker's proposed approach.
I'm sorry, some process of what?
Of collecting that money from the customers and eventually providing it to the bondholders in your two equal payments that you say are necessary.
Are you asking if something has to happen from the time a customer remits a payment to the time the bondholder receives it? Yes.
Okay. Now, is it your understanding that Mr. Brubaker's position is that this equal percent allocation to the base components of a bill has been applied in other states?
I do not believe what Mr. Brubaker proposes has been applied as he proposes it in any other state. My understanding of the Louisiana cases that he referenced in response to data requests is that those were applied as charge adjustments to existing charges and not as a percentage adjustment. Because Mr. Brubaker didn't file any evidence related to that, I don't know significant detail on it, but from what I was able to research through the Louisiana Public Utilities Commission website with regard to the hurricane charges for distribution system damage. That was my understanding of the outcome in those cases.
Okay, but you weren't in those cases, just for the record? You as a witness were not in those cases, correct?
I was not a participant in the state of Louisiana processes, correct?
Okay. That's all I have. Thank you, Your Honor.
Any cross-examination from public counsel?
No, thank you.
Any cross-examination from Ameren, Missouri?
No, thank you, Judge.
Any commission questions? I hear none. I have a few questions for you.
Sure.
Let's start with the allocation of the revenue requirement, since you're up on all three issues. You heard me ask a question of Will's in regard to whether or not an extra true-up would be required. And Mr. Wills had indicated, and I asked him to do some mental gymnastics, but he had indicated that he did not believe it would. And you heard his explanation, which was maybe a bit above my head. Does that sound correct to you?
So with all due respect, the use of a true-up can be have a very precise meaning within the industry. Having heard your question, if I understood it correctly, is your concern, if we set a sucked charge at a flat rate of something like 1.8%.
And by suck, you mean securitized utility tariff charge?
I do, my apologies. So if coming out of this case, let's assume that a rate is set at 1.8%, and let's assume that we're comfortable introducing volatility into the pricing, so it is 1.8% all year. If then Ameren gets, let's say, to make the math easy, a 10% general rate increase, you would either need to recalculate that 1.8% charge or accept the fact that ratepayers will be substantially overpaying. So a process and timing for doing that would need to be designed into the sucked mechanism itself, because the commission is not able to touch these tariffs, if you will, other than through their own provisions once they're set out and promulgated. Does that answer your question?
I believe so. Can you explain how customers would be paying more?
Well, if you're getting charged an additional 1.8%, and you're getting charged 1.8% on a $100 bill, and then your bill goes up to $110, you would then be getting charged 1.8% of $110, which is more.
Okay, thank you for clearing that up for me. You have several propositions regarding changes to the tariff. Can you direct the commission to the provision of the statute that supports your tariff positions?
Oh, give me a second here. So I think the ones that are probably kind of in question here are going to be those provisions that are more under item 20 with regard to the
Bypassability?
bypassability, yes. And those are, if you would just like the statutory reference, it would be 393.1700.1 paren 16 close paren. There's further guidance, 393.1700.
Hold on just a second.
I'm sorry.
And you're talking about that section that says securitized utility tariff charge.
Yes,
Okay, and you said there's another?
there are 3 total that I am aware of.
And just that says, that's the non-bypassability provision.
Part 1, if you will. There's
Okay, go on.
The second one is 393.1700.2 paren 3 paren C small letter D. which further addresses that.
A requirement that for so long as the securitized tariff bonds are outstanding?
Yes, that is the first sentence of it. And then the third one that I am aware of is 393.1700.11, small, or paren 1, paren A.
After the provisions of this section?
Yes. And I believe that those are all set out in staff's position statement, if that's an easy place to look those up. I mean, certainly the commission can rely on its own organic statutes or enabling statutes, so.
Yeah, I appreciate it. Anytime anybody can point me to an easy spot to find something, I appreciate it.
Yeah,
It makes
yeah,
my,
those-
my job easier. Why do you think those support, or how are you interpreting those that they support your, and that you can do it however you want to? You want to talk about the tariff or the non-bypassability?
So those are specifically addressing the non-bypassability issue that is under issue 20, and also part of issue 17D. I see issue 17D and issue 20 as being more or less the same issue, although they were split out in the issue statement negotiation. So I guess to give you the short answer, I view those as being consistent with the commission's interpretation because it's relying on the language that the commission has promulgated with regards to the Evergy and Liberty tariffs, where the commission apparently determined, whether explicitly or implicitly, that that language was necessary under the tariffs. The slightly longer version is non-bypassable, I believe means non-bypassable. And the concern that issue 20 is really drawing to a head is if in the very rare instances, I can think of 3, I believe, total, since I've been at the commission, going on 20 years now, where there are territorial agreements involving customer swaps. It's just clarifying what happens that you effectively can't get out of a sucked charge by virtue of a customer swap territorial agreement. And clarifying what occurs in the event of mergers or other fairly rare activities, change of suppliers, fairly rare activities that all require commission authorization or action in some way or another. It's not intended to cover the provision, and I don't believe the language does cover the provision, where let's say that you're an Ameren customer and you move, and you would not be, if you're an Ameren customer in Columbia, if you're an Ameren customer in Jefferson City, and you sell your house and move, nothing in the tariff that staff has proposed would require that you still pay that customer charge if you move to the state of Colorado or an area outside of the service territory. It's literally for where the certificated areas of the utility are being impacted.
Isn't that true, though? I mean, let's take the fuel adjustment clause,
Sure.
where it's a minute amount of money. Obviously, it's not the securitized tariff. If I move out of a territory in the middle of the month, I'm not going to have to pay the fuel adjustment change, which will be in the coming month, correct?
Without getting into the details of the fuel adjustment charge, yes, you absolutely would. You would be issued a final bill.
Ah, okay.
And another distinction there would be that the word non-bypassable isn't in that fuel adjustment clause enabling statute. And
I didn't mean it was.
Yeah.
I was trying to, it was not perhaps the most apt analogy. But let me ask you this. Under the way you propose it, if I'm an Ameren customer and I move out of the area, I still have to pay that securitized utility tariff charge?
absolutely not. No.
Why not? That's what I'm a little unclear on.
What the language is saying is if you're an Ameren, Missouri customer and your attorney comes to the commission and requests that you have your supplier changed, or you're an Ameren, Missouri customer and you go talk to a neighboring co-op or a municipality and say, hey, let's see about getting a territorial agreement involving customers going, that is when the charge would follow you. It would not follow you if you simply cease, again, the wording of these issue statements is a negotiation. It's a hurried process. The wording of 20, I don't believe is, frankly, the way I would have worded it if it were up to me. It is not at issue whether changing supplier through movement of the customer, the charge follows them. What is at issue is if there is a change of supplier case or a territorial agreement case, what happens to those charges?
Thank you very much for clarifying that. I was very confused. I was concerned that people might switch from Ameren to, say, Liberty and be paying for two plant closures.
And that would only be the case if they were switching to Ameren, from Ameren to Liberty by virtue of
Of
a
a
territorial
territorial
swap
agreement.
or other, yes.
Okay. And I can understand the merger concern. Indulge me for just a second while I see if I have any further questions. I do not. Any recross from MIEC? Any recross from MECG?
No, thank you, Judge.
Any recross from the Office of Public Counsel?
Thank you. Why is staff singling out change of suppliers and territorial agreements as opposed to other movements of customers out of an Ameren, Missouri service territory for purposes of the securitization charge?
Is the question, I'm sorry, I don't understand that question as you phrased it.
All right, you're saying that the securitization charge should follow customers who leave Ameren, Missouri system in the context of a change of supplier agreement or a territorial agreement, are you not?
Can I, based on how you phrased that, I think maybe I can clarify the confusion there. I guess staff's recommending that the charge follow when the Ameren, Missouri system is changed around a customer. Might be the better way to phrase it. In other words, it's not about a customer is stationary. Let me rephrase. Sorry, re-ask your question, I suppose.
Well, just what is it staff's position on how change of supplier, if somebody's moving, currently a customer of Ameren, Missouri, they'd be subject to the securitization charge, and then they get a change of supplier request or allowed to change suppliers to no longer be an Ameren, Missouri customer. Staff's position is that the charge would still apply as long as Ameren, Missouri has a charge, is it not?
If that is done through a change of supplier in the, I guess, legal commission sense and not simply as a change of supplier in, I guess, the colloquial sense. In other words, if there's a commission case to change supplier, yes. If I just happen to move, no.
And why is staff drawing that distinction for the charge following a customer?
I believe that implements the non-bypassability language as the commission has relied on that in approving the tariffs for Liberty and Evergy. You know, it's kind of new territory for us in interpreting this statute, and that's what the commission found acceptable in those two cases.
If I understand your answer correctly, you're saying it's because the commission did it that way in the past?
It's more than that. It's staff threw that out in the Evergy and Liberty cases as what we thought was a reasonable interpretation of the statutory language. And from my understanding, the commission has relied on that interpretation and gone forward with that.
Aren't the change of supplier agreement, changes of supplier that you're referencing, don't they require a commission approval?
Yes, and that's why we're singling them out, is those instances where a commission order is changing circumstances around who is served by Ameren, Missouri.
And can't the commission take into account the impacts of a securitization charge in the context of deciding whether to allow a customer to change suppliers?
To be blunt, that's not an area that I've worked extensively in recently as for what the actual legal requirements are in a change or supplier case, so I can't answer that.
Doesn't the commission also approve territorial agreements?
They do, which again is why we're including them in this non-bypassability language.
And can't the commission take a look at the impacts on customers of securitization charges in the context of deciding whether or not to approve a territorial agreement?
Again, I don't know. There's specific rules and guiding law on that, and I haven't looked at it in the last, couple months.
No further questions, thank you.
Any recourse from Ameren, Missouri?
Just a little bit, Your Honor. Good afternoon.
Good afternoon.
The judge asked you some questions. I think maybe it was the same question or the same topic that he asked Mr. Wills about, and that was this issue of whether there might have to be an additional true-up if you adopted Mr. Brubaker's approach, the base revenues approach, right?
I recall that.
If the securitized utility charge tariff, the tariff that will govern that charge, if it includes a formula and one of the variables in that formula are the base revenues, then if you update the base revenues with each rate change, you wouldn't have the overcharge problem that you suggested to the judge. Is that right?
If the question is, if we wrote a tariff around the problems, could we avoid the problems? Probably. The timing and place and how we do that is a big question mark to me, but, if everybody puts their best efforts in and is cooperative and transparent, could a tariff be designed that addressed that particular issue? I think the answer is yes.
I mean, you characterize it as a problem, but if the problem is that you need to update the base revenues and you got to come to agreement on the tariff, if you solve that problem, you won't overcharge customers, right?
No, so the problem is figuring out how to design a mechanism that nobody's proposed in any kind of detail and what all we need to include in this tariff. So I'm ashamed to say this, but the issue the judge raised had not occurred to me prior to today, and that's a big issue. And I don't know what other issues we haven't thought of yet with regard to the MIEC proposal.
Okay, thank you.
Before we get to redirect, I actually have another question. And maybe I misunderstood. You said that this is not the way it was done in either Liberty or Evergy. Is that correct?
The allocation or the territorial?
The non-bypassability.
The non-bypassability language staff has included in its proposed tariff is, I believe, word for word identical to Liberty, and I think is incredibly similar to Evergy. If I recall correct, we took two sentences that were in different places in Evergy and stuck them next to each other in the Liberty tariff.
So Liberty does account for a territorial change?
Yes.
I was unaware of that. Thank you.
Yes, this language for the non-bypassability is drawn directly from the approved tariffs.
Thank you. Any recross from MIEC? No questions. MECG? Public Counsel?
Thank you, no.
Ameren? Redirect from staff?
I think just very, very briefly. Do you recall the cross-examination you had with counsel for MECG?
I do.
And you discussed that he suggested that if you alter the timing of the payments, that you would avoid the problem you pointed out in your rebuttal, but your response was that created a new problem in volatility. Do you recall that?
Yes.
Can you explain what the issue with volatility is?
Where to begin? So while it's easy to kind of think of classes as having, saying an equal percentage charge sounds really simple. In reality, within each class, from LPS down to residential, and especially for the large general service and small primary service customers, which is where the majority of the the industrial customers in the state of Missouri actually are housed for Ameren, Missouri purposes. You have a really complex rate design that you're charged, most customers are charged the same amount every month as part of their customer charge within their class, but then energy charges vary by the time of the year. For LGS and SPS customers, energy charges vary very drastically depending on their load factor, their non-coincident demand, and other factors, such that I know I had just looked at within the LP class, the large power service class, we have customers who are paying as low as 5 cents per kWh and customers who are paying close to 12 cents per kWh on an annual basis, and that is even more volatile month to month. And so when you get into LGS and SPS, where again, there's a tremendous diversity of customers, you could have customers who might be paying an average of 4 cents per kWh in a winter month and might be paying 20 cents per kWh in a summer month. And so when you try to apply a flat percentage to those, not only do you have tremendous volatility customer to customer, but that compounds on itself, and you have tremendous volatility month to month. The figures I presented in my rebuttal testimony are based on normalized and annualized values. They aren't reflecting actual weather, which is only going to increase that volatility. And it's definitely not reflecting the diversity within individual classes for what customers actually pay, much less what customers actually pay month to month. And that's before we even get to billing cycles, which, depending on the class, double to triple to whatever you call something times 28, the difficulty in how uniform that impact on customers would actually be. And what the revenue availability would be to fund the bond proceed, or to fund the bond payments.
Could that volatility and recovery impact pricing or overall cost paid by all customers of that bond?
I've negotiated 2 of these tariffs in direct conversations with our bond counsel and the utility, and I don't know how many times we heard, you have to word it this way, this is what the bond community expects. Everything comes down to consistency, everything comes down to predictability. Missouri has a lot bigger winter and a much different summer than Louisiana does. Whatever happened in Louisiana is not what the bond community is going to have experience in Missouri as far as seasonal revenue volatility associated with changes in weather, changes in applicable rates. I don't think that getting that level of comfort with the bond community, I can't imagine that being an easy process, and based on my experience in working with the other utilities and developing their tariff and the insistence on very precise language that has occurred there, I can't imagine that if anything they were saying was true, this would not impact the overall bond payment requirement.
You just mentioned the Louisiana cases. You also had a conversation with counsel for MECG about those. Do you recall that?
I do.
You reviewed those cases, correct?
In part, there's quite a bit of while Mr. Brubaker's testimony was very scant, his data request responses had more cases. In general, in my rebuttal testimony, I indicated that those cases were not really comparable to Missouri. But I have not reviewed all of them, but I've reviewed some of them, I guess is the fair answer.
Do you recall if in some of those cases, or to the extent you recall, were those storm costs?
Yes, I believe all of the Louisiana cases were to deal with primarily damage to the distribution system, secondarily damage to the transmission system, and I believe to a small extent maybe interruptions in some production at gas-fired plants associated with, I think it was storms Rita, Katrina, and I apologize to our neighbors to the south, but I don't recall the name of the other major hurricane that was implicated in that. And those are very different than the sort of costs we're looking at here today.
Finally, would volatility, are you just concerned about volatility for the residential class, or is volatility in these payments an issue for large customers, all kinds of other customers?
So if the solution, so I think as a practical matter, what Mr. Brubaker has proposed, it can't be done. Having a set percentage that runs year-round, I don't think there's any way that could be implemented. So the answer to that, to stick closer to his proposal, would be to adjust the percentage applicable during the year to account for the volatility in revenue during the year. I think, frankly, that's going to have the biggest impact on large general service and small primary service customers, even more so than residential small general service customers. It'll also have impact within the large power service, simply because their rates are very seasonal. You know, there are differences in what residential customers pay summer to non-summer. There are huge differences in what non-residential customers pay summer to non-summer. And especially when you have so many customers in the large general and small primary classes that are on hours use rates and that have these elements of seasonal demand, seasonal energy charges, I think they have a hard time knowing what their bill is going to be next month, much less once you factor in what percentage gets applied to that when we might be, I mean, based on my preliminary analysis of weather normalized numbers, you know, I think it's in my testimony that we should expect that rate is going to swing, you know, the percentage rate could double on itself and have itself on the various 6 months of the year.
Okay, thank you so much. I have nothing further.
Ms. Lange, you may step down, and I believe you're excused.
Thank you.
I believe, am I correct that the next witness is MIEC's? You may call your witness.
Hey, Judge, this is Commissioner Holzman. Can you just refresh me on what issue and subsection we're on right now?
Absolutely, Commissioner. We have combined 3 issues together for the purpose of this due to the overlap of witness and the expediency of it. So this is all of issue 16, all of issue 17, and all of issue 20.
Perfect, thank you.
Thank you, Commissioner. Mr. Brubaker, would you raise your right hand and be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated. MIEC, go ahead.
Good afternoon. Mr. Brubaker, by whom are you employed and in what capacity?
I'm employed with the firm of Brubaker and Associates, utility rate and economic consultants.
Did you cause to be filed in this case rebuttal and surrebuttal testimony?
I did.
And if I asked you the same questions that are in that testimony, would your answers be the same today?
Yes, they would.
Do you have any amendments or corrections to your testimony?
I do not.
Okay. At this point, then, I would go ahead and ask that exhibits 550 and 551 be admitted into the record and tender Mr. Brubaker for cross-examination.
I have you, are you talking about as direct and rebuttal, or?
That would be rebuttal and surrebuttal.
I have those as 501 and 502. Am I incorrect on that?
Oh, I had 550 and 551, but I could have the numbers wrong.
Hold on just a moment. You are correct. They are wrong on the exhibit list.
Okay.
So that the direct and the rebuttal, is that correct?
That would be rebuttal and surrebuttal.
Okay, you currently have direct listed as 500. Is that going to be a different number?
No, actually, we only have rebuttal and surrebuttal, so it's 550 and 551. So anything to the contrary in our exhibit list would be wrong.
Okay, are there any objections to admitting Exhibit 550, the rebuttal testimony of Mr. Brubaker, or 551, the surrebuttal testimony of Mr. Brubaker, onto the hearing record? I hear none. Exhibit 550 and Exhibit 551 are admitted onto the record. You tendered the witness, right?
Yes, for yes.
Any questions from MECG?
Yes, Your Honor. For the court reporter, this is Tim Opitz, MECG. Mr. Brubaker, your method has been adopted in other states, is that right?
Yes, it has.
And so it's safe to say this mechanism is not some novel, untested way of collecting securitized charges?
Correct. I provided a number of examples, many of them from Louisiana, which is securitization of storm costs, and that has proved to be very implementable and workable
So,
in Louisiana, even though their seasonal variations are much greater than we have here in Missouri.
so you mentioned Louisiana. In Louisiana, did the bond community have any issue issuing bonds based on this kind of mechanism?
No, a number of series of securitization bonds have been issued with the basic structure that the collection mechanism from customers is an equal % of base rate revenues each month, funds being sent to the collection agency, I think they're a collection agent.
So
There have been no problems with collecting the revenues from the customers or from paying the bonds.
So in your experience with these kinds of bonds and being collected in other states according to your method, there hasn't been any issue with volatility in those bond payments?
No.
In your experience, would the tariffs under your method be more or less complicated than the tariffs under the staff's method?
They're much more direct and less complicated than the method proposed by the staff. It's a simple matter of calculating the percentage and then applying that to the customer's bills on a monthly basis.
Under your method, there's been some discussion about what happens at a rate case. Under your method, what would have to be done during a rate case to update any securitization charge?
I think following the change in rates in a rate case, you would have new base rate revenues. And so the servicing agent or payment agents, whoever's involved in that process, would simply have to recalculate the percentage that would apply to base rate revenues under the new set of tariffs. And that would all be folded into the true-up and collection process.
And there shouldn't be an issue with the bondholder because they're still getting their money?
Correct. There have been lots of changes in rates in Louisiana, and it's not been a problem.
There was some discussion of the kinds of class cost of allocations that you have recommended in the past earlier in today's hearing. Do you recall some of that discussion?
I do.
And if I'm remembering, some of the discussion was about the impact of a average and excess method, allocation method, compared to a energy allocation method, and compared to, I'll call it the base rate method that you're proposing in this case. Is that a fair characterization of what was discussed earlier?
Yes, that's what I recall.
And how does the average and excess method compare to what you're proposing in this case for allocation?
I had looked at this as I was putting together my proposal for this case, and I looked at the data from the just concluded rate case. And it turns out that for at least residential and large primary customers, that the base rate shares and the average and excess demand shares are roughly the same. So if we use average and excess, or we do what I did, base rate revenues, it's fairly comparable. For example, rounding off to whole numbers, for residential customers, the base rate shares 51%. It's also 51% under average and excess. And for large primary, it's 8% under base revenues and 7% under average and excess. In contrast, for the large primary, instead of 7 or 8%, the energy allocator is 11%, so it's 40% greater. And for residential, it's pretty much the reverse. The energy factor would be 43%, which is 20% less than the average and excess or the base rate. So much bigger, much larger differences. I considered using average and excess, but I realized that we've never really had a commission order that prescribed officially a methodology. And so while I could propose that, other people would say, well, that's not really been adopted. So I looked at the base rate revenue method, which is pretty standard in a lot of places, and saw that it was comparable and a whole lot easier to implement. So that's why I went with that.
So there was some discussion that you didn't offer exemplar tariffs in your testimony. Would you agree with that?
I did not offer exemplars, correct.
Would it be difficult to develop tariffs to implement your allocation method?
No, I don't think so. The same basic kinds of provisions would apply under either methodology of collection. The numbers would be different, and you might have some timing differences, but basically you're trying to accomplish the same goal, which is to be sure that you collect the money you need to collect to service the bonds and do so in a way that's secure and clear.
And in fact, it's your testimony that there are other states we can look to model these tariffs off of?
Yes, yes.
That's all I have, Your Honor.
Judge, could you give me about 1 minute? I have to plug in my machine real quick. I'm so sorry about that.
Absolutely. We'll
Just
go off the
1
record
60
for a moment.
seconds.
Okay, let's go back on the record. Mr. Opitz, you indicated you were finished?
I am, Your Honor.
Thank you. Any cross-examination for Ameren, Missouri?
No, Your Honor.
Any cross-examination from the commission's staff?
Just very, very briefly. You said it would be relatively simple to develop tariffs that align with your proposal. Is that correct?
It's been done many times in other places, so I think that would be the case.
If parties had a disagreement over the language in that tariff, how would that disagreement be resolved in this case?
The same way any disagreement with what anybody filed would be resolved.
So you envision us having another hearing in this case to solve those issues?
I would like to think that parties have done this enough that we can come to terms on agreement without having to go through the process of another hearing, but that's always the fallback if nothing else works.
Okay, thank you. Nothing further.
Any cross-examination from public counsel?
No, thank you.
Are there any commission questions? Commissioner Coleman, please. Oh, I'm sorry, I misunderstood. There are no commission questions at this time. I do have some questions for you, Mr. Brubaker, and I will start with issue 16, the allocation of the revenue requirement. Do you have any suggested changes that should be made to either Ameren's or staff's proposed tariff if the commission were to approve MIEC's allocation method?
Judge, no specific language changes come to mind. It would just be a matter of conforming the language in the tariffs that are designed to provide the basic functions like true up and all that, and changes in rates, just to convert the language from a per kilowatt hour collection factor to a percentage allocation factor. So the same basic structure would prevail or would apply.
From what you said, you indicated you did not think an additional true-up after a rate case would be needed? Or
There
an
would not be.
additional adjustment?
That's right. After the rate case, after the rates change, then part of the true-up process would take place to look at the new revenues that are the base rates to which the percentage is applied. And since presumably it's going to be an increase in base rates, if you don't change the amount of the bond payment obligation, then the percentage that you had to apply to customer rates would go lower, and you would need to account for that as part of the true-up process for the securitization. But it wouldn't change the tariffs or anything in the rate case. The rate case output would just be an input into the process of developing the appropriate percentage collection factors to get to the end result, which is the final guidepost, and that is we actually collect the money in time to pay the bonds when due. It would just be a mechanical process. For example, if we increase base rates by 10%, then in theory, the percentage you apply to those base rates to get what you need to service the bonds would go down by 10%. So if I'm collecting $10 and my base rates now are 100, that's 10%. If I go to 110%, then that becomes a smaller percentage, like 9-point-something% to achieve the same end result.
Okay. Has this methodology been applied to a plant closure before?
I'm sorry, Joe, what?
Has this methodology been applied to a plant closure before?
I don't know that it has. I know there's about to be one in Louisiana for a plant closure. It was filed Monday, I think, this past Monday. So it will be the same methodology.
And that methodology was approved?
It's pending commission approval. It's a unanimous settlement, and those usually get approved. I can respond back if that's not the case. We expect it to be approved. But the mechanics are the same, regardless of what we're securitizing, whether it's generating plants, transmission, distribution, or anything else.
Any recross? MECG?
No, thank you, Your Honor.
Ameren, Missouri?
Just a couple, Your Honor. Afternoon, Mr. Brubaker. I can't
It's hard
speak.
to say. Good morning, good afternoon.
Judge asked you some questions about this possibility, or at least the theory that there could be an extra true-up after a rate case as part of the securitized charge tariff, right? You remember those?
I do.
I think what you're saying, and I think this is similar to a question I asked Ms. Lange, you're going to have to take the output of the rate case, what the base revenues are after the rate case, and then you'll have to plug those new base revenues into the formula in the securitized utility tariff, right? That's what you're saying.
Precisely, yes.
And that's all. It's just changing a value of a variable in that securitized utility charge tariff, right?
Correct, yes.
And what you just described isn't, I don't think Mr. Wills described the mechanics exactly like that, but isn't that exactly what Mr. Wills explained to the judge when he was asked a similar question?
Yes, it is. And it's not rocket science, it's just basic math.
Okay, thank you.
Any recourse from the commission staff?
Just very briefly. It sounds like you, Mr. Wills, and Ms. Lange all believe that at some point after a rate case, numbers will need to be adjusted. Just the timing of that, sounds like there's differences in when you believe that would happen. But you agree that a true-up of those numbers will have to occur, they have to change.
It has to be cranked into the calculation of the collection factor. Now, whether it occurs the day after the rate or a month after the rate, we have a kind of a smoothing process that applies to translate the collections from customers to the payments to bondholders. And so there's plenty of room for true up in there, so it's not something that has to be turned on a dime.
Okay. In your experience, does the commission always order rate-based revenues as a finding of fact or conclusion of law? Billing determinants, are they ever set out in any specific, often in
There's
the quantity of the base revenues? Is that a simpler, maybe easier way to say it?
If I think back, I think the commission either orders a revenue requirement or an increase over current rates, and then the utility takes that input and calculates out what the revenue would be under their tariffs, and then adjusts the tariffs to collect the revenue that the commission has prescribed. So they may not have it in order, but it's clear by the time you approve the new rates, everybody knows what those numbers are, and there's no question about it.
So in a black box settlement, you would be able to tell what the base rates were?
Yes, because
Revenues, sorry, base revenues.
yeah, the commission, the company has to produce revenues, produce rates to produce the revenues. It's immaterial what the particular findings of fact were that generated that. The operative factor is what is the base rate revenues, and that's never a mystery.
For your calculation, your method, would you need to know those base revenues to true it up after any rate case, or however you want to, whatever you would like to call the adjustment?
You would need to know what it was and how it changed so you could calculate the new percentage to apply to customer rates going forward, subject to true ups, and that's just a very simple matter.
Okay.
Public counsel?
No, thank you.
Any redirect from MIUC?
Yes, thank you, Your Honor. Mr. Brubaker, Mr. Opitz asked you questions about ease of administration of your proposal in a tariff, and also the issue of volatility that's been raised by Ms. Lange's testimony, that there would be some difficulty or unpredictability in rates that would potentially affect how the bondholders would view this. Could you respond to those concerns?
Sure. The bondholders are concerned with getting their money. The mechanism by which that happens is of less concern to them. What is concerned is that there are procedures and processes in place that are clear and not subject to wide interpretation that would affect the ability to reach the amount of revenue necessary to service the bonds. That's what's most important. I don't think that the month-to-month changes have any real bearing on that. I would also note that the percentage we're talking about here is less than the percentage that gross receipts tax are. Gross receipts tax can be 4 or 5%. We're talking about 1.8%. So there would be less volatility introduced by my proposal for collecting securitization payments from customers that already exist in terms of paying for gross receipts tax.
I don't have any other questions, thank you.
Thank you, Mr. Brubaker. You may step down.
Thank
You
you,
are
Judge.
excused.
Thank you.
Public counsel, is your witness ready to move on to 18?
Yes, she is.
Give me just a moment. Please call your witness.
Thank you. Nathan Williams, Public Counsel calls Angela Shaben to the stand.
Ms. Shaben, would you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing today is the truth?
Yes.
Ms. Shaben, you've testified at this hearing previously, have you not?
Yes.
And you have rebuttal testimony that's been marked as Exhibit 209?
Yes.
Judge, I offer Exhibit 209.
Are there any objections to admitting Exhibit 209, Shaben's rebuttal testimony, onto the hearing record? I hear and see no objections. Exhibit 209 is admitted onto the hearing record.
I offer Ms. Shaben for examination.
Any questions from MIEC?
No questions, thank you, Your Honor.
Any questions from MECG?
No, thank you, Your Honor.
Any questions from the commission staff?
No, Your Honor.
Any questions from, or cross-examination from Ameren, Missouri?
No, thank you.
Are there any commission questions? And just, I didn't reiterate what the issue was, so I'll do that now real quick. Should certain amounts remaining on capitalized software and office equipment furniture, which are identified by public counsel witness Shaben, be excluded from the cost to be financed using securitized utility tariff bonds? And that is under software and office equipment / furniture.
No questions, Judge. Thank you.
Thank you, Commissioner Holzman. Any other commission questions? I have, I believe, just one. Can you refer the commission to a portion of the securitization statute that supports public counsel's proposed exclusion of these costs?
I can't point to a specific part of the securitization law that excludes these.
What are you using as your basis to believe that these costs should be excluded?
Well, the fact that there's less remaining life of these assets as opposed to the length of the bond, which with all of the, I guess my main concern is the excessive use of estimates, that the overall bond price would be higher, which would then incur more carrying costs, upfront financing fees, and then during the reconciliation process, the statute isn't quite clear on how those things will be reconciled. Like, your upfront financing fees aren't going to be given back if the estimates are too high.
Well, these are items that are at Rush Island, correct?
For now, yes, and they weren't included on the list of
materials that salvage, they weren't listed on anything that could be sold for, recovery.
Now, when you said that there wasn't much useful life left, my recollection in looking at some of these items was that it was periods of times from like 3 years to 9 years of useful life remaining. Is that correct?
Yes, the software itself only has like a month-ish, like not very much left.
And I'm not trying to be cheeky here, but are you concerned that people will take office chairs home?
No. No, I mean, that's, if it's not, I mean, they could, I guess. If it's not in the salvage amount, then they're not going to be salvaged, so what else are you going to do with them? I mean, are they going to just stay at the plant while it's being demolished? I don't know.
Is the logic that these are de minimis costs, that is the logic that these are de minimis costs and therefore shouldn't be securitized? And well, I'll stop there. Is the logic that these are de minimis costs?
That's the logic.
But they are technically plant, correct?
Technically.
And when you're talking about securitization, obviously for a bonds become more attractive to buyers the higher that amount's securitized, correct?
That may be the case.
Thank you.
Yep.
Any recross from MIEC? MECG?
No, thank you, Your Honor.
The commission staff?
No.
Ameren, Missouri?
Just a couple, Your Honor. Ms. Shaban, isn't it true that if the company moves a desks or office chairs or whatever from Rush Island to another plant, then that's going to reduce the amount that's associated with Rush Island, and in the reconciliation process that the statute requires take place later, then if the estimate's too high, then customers are going to get credit for that. And if the estimate's too low, customers will get, the company will get credit for that. Isn't the way it's going to work?
I could see that, but I didn't see any of that.
Well, my
in the
question was,
case.
is that how it's going to work or not?
It could work that way.
Well, isn't
I
that,
don't-
it's not that it could work that way. That is what the statute is going to require, isn't it? Do you know? Do you
Mr.
know?
Lowry, I'm going to caution you to stop cutting off your witness before they can answer your question with another question.
Okay, fair enough, Judge. Thank you.
Well, I read portions of the statute. It's very long, and would that be a legal opinion?
Well, do you know whether the statute requires a reconciliation process?
I do know that. I'm just not sure how there's not very many details on the process, so it's just a reconciliation. I don't know how that process is going to work.
Did you read Mr. Will's direct testimony in this case?
I didn't. It's been a while.
Do you recall that he described the reconciliation process?
I'd have to go back and read it again.
Are you aware of whether or not any OPC witness took any issue with how the reconciliation process was going to work?
I'm not aware of that.
I want you to assume the statute does require a reconciliation process. The statute will say what it says, and the commission will understand what it will understand about that. But I want you to assume that it requires that if an estimated amount is used to set the principal of the securitization bonds, that later in a future rate case if the actuals come in different than the estimated, that the statute requires those to be reconciled. Can you assume that for me?
Can you repeat that? Sorry, I was thinking.
I want you to I'm asking you to assume that the statute requires that whenever an estimated amount is used to include an item in the principal amount of the bonds, that the actuals have to be tracked, and in a later rate case, when we know the actual number, the statute requires that the estimate be reconciled to the actuals. Can you assume that?
That sounds right.
And if that's the case, then if it turns out that the company transfers some of these items to another plant and that the estimate was too high, then customers are going to get the difference back via a rate case, aren't they?
Of that part, we don't know about the interest or the upfront costs, which they'll still be incurring because of the overall bond amount. But yes, I can agree with that.
Okay, thank you.
Any redirect?
No, thank you.
Ms. Shaven, you may step down, and I believe you're excused.
Thank you.
Now, if you'll remember, we had talked about issue 19. Ms. Plesia, have you heard back from, I can't think of his name.
Mr. Kaufman?
Thank you so much. I don't know why it slipped my mind. I've said it so often.
I have heard back from him. He said whatever order that the issues are taken in is fine with him, and he will have no objection to any order.
Well, and just to clarify for the record, what I'm discussing is the parties have proposed, because the commission's decisions on other issues will ultimately determine the amount to be securitized, which is the question 19, after the resolution of all other issues herein, what amount should the commission authorize Ameren, Missouri to finance? That because the commission's resolution on other issues ultimately will determine those amounts, the discussion was to waive the live testimony and admit the or waive cross and admit the testimony. And in this case, some of the testimony isn't going to be admitted just yet. But is that correct?
Mr. Kaufman is fine with that proposal.
Okay, thank you for letting me know. Ameren, Missouri?
Are you asking about issue 19 and the proposal on issue 19? I apologize.
I am. I'm asking if you're waiving cross.
We are.
Staff, are you waiving cross?
Yes.
Public counsel?
More issues there.
Yes.
I can invent a few if you'd like. I have one about Santa Claus and the coal. Public counsel?
Waive cross as well.
MIEC?
MIC will waive cross as well.
MECG?
I will waive, yes, Your Honor.
And I will note for the record that AARP and Consumer Council of Missouri are also okay with that. The other parties have been excused from today's proceeding. So the proposal will be granted, cross has been waived, and we will deal with it does not appear that there's any testimony in here that isn't going to be admitted at the end of this proceeding. So we'll move on to issue 21, which I believe is our last issue. Is that correct?
Judge, I think you have a couple witnesses yet on 18.
I apologize. I jumped ahead, and nobody stopped me.
Well, I was going to bring it up, but
Okay.
Mr. Williams beat me to it.
We have resolved issue 19, so let's come back and finish off issue 18, and I believe staff has the next witness. And I apologize again for being out of order.
Are there any questions for Mr. Majors on issue 18? but any of the parties. I haven't had the opportunity to ask any of the parties. I don't know if it's in the interest of moving witnesses. Well, we can bring him back to the stand. Why not? Go to the witness stand.
I actually may have a question for Mr. Majors.
Okay. There we go.
And I'll remind you, you're still under oath. And Mr.
Your
Key-
Honor, Mr. Majors has been up multiple times during the hearing, so his testimony has already been marked, and I just tender him for cross on issue 18.
Any cross-examination from MIEC,
No questions, thank you, Your Honor.
MECG,
No, thank you, Your Honor.
Public Counsel,
No, thank you.
Ameren, Missouri?
2 questions, I think. Mr. Majors, staff is recommending inclusion of these software costs and the office furniture that Ms. Shaben has recommended to exclude from energy transition costs, correct?
That's correct.
And if the actuals turn out to be different than the estimate, then that will be reconciled in a future rate case, right?
That's correct.
Thank you.
Any commission questions for this witness?
Judge, I don't have a question on this particular issue, but I just want to commend Mr. Majors. He has been a witness on, I think, a majority or at least the majority witness on a lot of these issues. And so I just want to, as we come to the end here, if he doesn't come back, commend him for his testimony throughout this proceedings. Thank you.
I'm sorry, who is this?
That is Commissioner Holzman.
Thank you. I appreciate that, Commissioner Holzman.
Okay, I have, you heard OPC's proposition that these should be not included in securitization because of the de minimis amount of this various office furniture and software. What's your opinion on that?
Well, those costs, as Mr. Lowry pointed out, we've included those costs in the securitization balance. We haven't treated those differently for these purposes. I don't know that there's a particularly good an argument that comes to mind on why you would separate those out. And there could be the possibility that you would have some kind of salvage value. I think the Mr. Williams had noted that they would put bids out and offer that property along with other property, particularly the office furniture, to have some kind of proceeds after the retirement, some kind of potential sale proceeds. So I'm not, I think you would include those in the overall amount to be securitized.
And these would also be subject to the reconciliation process, correct?
Yes, they would.
Thank you. Any recross from MIEC,
No questions, Your Honor.
MECG? Public Counsel?
Yes, please, thank you. Let's assume you had the same carrying cost and bond rate between securitization and in a rate case. And for recovery of the software and office equipment costs,
Okay.
what kind of an amortization period would you anticipate in a rate case setting?
Judge, I'm going to object to that. I think that's beyond the scope of the bench question.
Would you state your question again?
I'm sorry, who is that now?
I'm not sure which voice you were referring to. I think you were referring to Mr. Keevil. He is, Jeff Keevil is an attorney for staff. Staff's attorneys have rotated in and out depending on issues, so he has taken over for staff.
Thank you.
Would you remind me your question, please?
My question was, what I'm getting toward is the difference between general rate case treatment and securitization, which I believe was what the commission was looking at in terms of the treatment as to public counsel's position.
Where do you think I crossed into that?
whenever you were asking about what staff understood public counsel's position to be on the case and talking about the impacts of securitization.
Judge, all you asked was whether staff's theory or OPC's theory that it was de minimis and therefore it shouldn't be included, what it was his opinion on this de minimis theory. That's all that you asked about, I believe.
I believe that's correct. I'll sustain the objection.
No further questions then.
Any recross from Ameren, Missouri?
No, thank you.
Any redirect from staff?
No, thank you, Judge.
Mr. Majors, you may step down.
And we'll call Mr. Lansford to the stand, Judge. I believe he's the last witness on this.
Mr. Lansford, I'll remind you you're still under oath.
And we tender him for cross-examination.
Bear with me for just a moment. Any cross-examination from MECG?
No, thank you, Your Honor.
Any cross-examination from MIEC?
No questions, thanks, Your Honor.
Staff?
No, thanks, Judge.
Public counsel?
No, thank you.
Any commission questions?
No questions, Judge.
I have no questions for you. You may step down, Mr. Lansford. You're also next, so you just want to stay in the hot seat.
That would be okay.
That would be fine with me. Now, before we go on to the next issue, I think at the time I asked, everybody thought there was still another day of hearing left. I had asked about a few items this morning. I had asked Mr. Pringle about whether staff intended to enter its proposed order as an exhibit. I don't know, or proposed financing order as an exhibit. I don't know that I believe that's necessary because proposed orders are fairly common, and I don't think that there was any argument about the order itself.
I agree with what you just said. I don't think proposed orders constitute evidence anyway, because like I said the other day when it came up, it's written primarily by attorneys. Attorneys aren't witnesses. So I did not personally plan to offer it as an exhibit. If you think there's some reason it should be offered or needs to be offered, I'm flexible on this, I think, but I did not personally intend to offer it.
Well, I agree with you. I mean, obviously, attorneys wrote it. None of those attorneys are witnesses in this case. It was reviewed by one of your witnesses, but that witness is not here. Proposed orders are fairly common. So I do agree with that. And I'd also ask about the district court decisions. And you indicated, Mr. Williams, that you thought you would be able to get those for me.
Yes, I have not yet, but I'm sure I have them. It's just a matter of supplying them.
I'm just concerned that they won't get into the record before the record closes.
The commission has taken exhibits after the close of the hearing before. They just leave an exhibit number open and identify what the exhibit's to be. I'd be happy to do it that way, or should be able to do it before the end of today.
Is there any objection from any of the parties in regard to handling it that way?
No objection from staff, Judge, and I was going to mention if Mr. Williams didn't, that frequently in these things we do what are called late filed exhibits, and the judge just reserves a exhibit number for the exhibits and takes them after this part of the hearing closes and just receives it as a filing through the normal filing process.
And gives the parties, of course, an opportunity to object if they think there's something wrong with it.
I am fine with handling it that way. Thank you very much, and thank you for proposing that. I don't believe that in my time at the commission that I've done that. I mean, I know I've reopened the record a few times. but-
Judge, if I could, and I apologize, this is due to my own, not having been here every day of the week. There was an issue earlier regarding the transcript from the hearing from March 28th, I believe.
I believe that's already made it into the record.
That was my question, whether that had happened in one of the days that I was not here.
I believe that. I
Okay.
believe that let me double check for you, and I will remind you that at the end, once our last witness is done, I generally go through
Right.
all exhibits with all parties to be sure that we have everything correctly entered and that my numbers line up with everybody else's. But I do see Exhibit 117 is the district court transcript, and it was admitted, and that is the transcript from March 28th.
Okay, thank you, Judge.
Judge, with regard to the opinion yet that needs to be offered,
Yes.
do you want to reserve a commission exhibit number or use an OPC exhibit number? How do you want to do that? Normally, a number's assigned and then it's provided.
Well, we've already decided how we're going to do that. I'd rather not keep the commissioners here any longer than is necessary, since this is really a housekeeping matter. So why don't we do that at the end before the hearing closes, but after the last issue?
Sure.
All right, thank you so much. And while I jumped the gun earlier, let's go ahead now and move to issue 21, which I believe is the last issue. Is that correct?
It is.
Okay. And Ameren's witness Lansford is already under the stand. I'll remind you again, for the second time, even though you're sitting down in the same spot, that you are under oath. And
Your Honor, I think we need to move it into the record since this is finally his last time before you. So
Okay.
I move for the admission of Mitch Lansford's direct surrebuttal and surrebuttal. Numbers. What numbers are they?
and those are 1C, 1P, 2, and 3. And I believe the surrebuttal is subject to a motion to strike. Is that correct?
It most certainly is.
Well, let's start with the ones that I don't believe are subject to, and that's any objection to admitting Exhibit 1, the direct testimony of Mr. Lansford, onto the hearing record? I hear none. Exhibit 1 and 1C and P are admitted onto the hearing record. Any objection to provisionally admitting Exhibits 2 and 3 onto the hearing?
Can I just get a clarification? You said surrebuttal. I think you meant surrebuttal?
I don't think there's any issue with rebuttal. I think it's just the
That's
rebuttal
subject.
is subject to
Okay.
the motion.
Yeah, yeah.
Thank
Just
you.
for clarification.
Okay, is there any objection to admitting Exhibit 2, the surrebuttal testimony of Mr. Lansford, onto the hearing record? I hear none. The surrebuttal will be admitted. And is there any objection to admitting the surrebuttal onto the hearing record provisionally subject to the motion to strike and responses that have been filed? I hear none. Exhibit 3 is provisionally admitted, subject to the conditions I just stated. Go ahead.
I tender the witness for cross-examination.
Is there any cross-examination from MECG?
No, thank you, Your Honor.
MIEC? The commission staff?
No, thank you, Judge.
Public counsel?
No, thank you.
Now, you're familiar with the Asbury cases, correct?
I am, yes, sir.
And just to state what this issue is, as I don't believe I did that, this is carrying cost rate. What rate, if any, should be used to determine the carrying cost that may occur between the retirement date of Rush Island and the issuance of the securitized bonds? Now, in the Asbury securitization case, the commission ordered a carrying cost rate of 4.65, which was Liberty's long-term debt rate for the period after Asbury was removed from rates until the securitized bonds were issued. Have costs associated with Rush Island been removed from Ameren's rates?
They have not, Your Honor.
When will they last be in Ameren's rates? Is it that October date?
They've not, Your Honor. It won't be that. They won't be removed from the customer's rates unless or until the company files a rate case and removes them from rates as part of a future proceeding. However, I'll note, and you know, Mr. Lowry talked about this on day one, the company has put forth the proposal to begin to defer the aspects of the Rush Island rates, or the costs that are included in rates today relating to Rush Island, and begin to defer those from the time of retirement until we're actually able to take them out of rates.
Okay, so basically set them aside until the next rate case.
Agreed, yes. Including carrying costs at the company's weighted average cost of capital as part of that deferral.
Do you anticipate that those will be removed before the bond issuance?
I do not.
Any recross based on bench questions? MECG? MIEC? Commission staff?
No, thank you.
Public counsel?
No, thank you.
Any redirect from Ameren, Missouri?
No, thank you.
Mr. Lansford, you may step down and you are excused.
Thank you.
I believe the next witness is public counsel's. Mr. Murray, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give today at this evidentiary hearing is the truth?
I do.
Please be seated. Public counsel?
Mr. Murray, you testified earlier in this hearing, have you not?
Yes.
And for the court reporter, how do you spell your name?
David for Murray.
And Judge, at this time, I'll go ahead and offer exhibits 201, 202, and 203, the rebuttal testimony of David Murray, the surrebuttal testimony with some corrected schedules, and David Murray's errata to his surrebuttal. That's in sequence 201, 202, and 203, with the understanding that there's a pending motion to strike portions of Mr. Murray's surrebuttal testimony that the commission is ruling on with the case.
I believe that's correct. So any objection to admitting Exhibit 201, the rebuttal testimony of David Murray, onto the hearing record? I hear none. Exhibit 201 is admitted onto the hearing record. Any objection to provisionally admitting Exhibit 202, the surrebuttal of David Murray onto the hearing record, subject to the motions to strike?
Judge, when you say subject to the motions to strike, I did not pre-file one before the hearing like Ameren, I believe, did regarding Mr. Murray's surrebuttal, but Monday, when he first took the stand, I think I raised objection to the end of his surrebuttal and two schedules that relate to that portion of the testimony.
Yes, I have that down. I believe it's 12 to the end, I have.
Yes, and schedules 8 and 9.
DMS 8 and DMS 9, and I have, I'm not sure what I meant when I wrote 12, so can you refresh my memory?
When you wrote 12.
I said staff objects 12 to the end. Is that page 12 to the
yes,
end?
page
Okay,
12.
that's what I,
That's where a new section of his testimony begins, at the top of page 12.
and it's page 12 to the issuance, advice letter, and post-financing.
That's the title,
Okay,
yes,
and those two schedules.
yes.
Okay.
Other than that, no subject to that, I should say, I guess, no.
Okay, you have no problem with me taking, well, let me ask this. Is there anybody who wanted to file a response or respond to the motion to strike beyond what's been done so far? All right, I will take that motion to strike with the case. So, again, any objections to provisionally admitting Mr. Murray's surrebuttal subject to staff's motion to strike? I hear none. Exhibit 202, the surrebuttal testimony of Murray will be admitted onto the hearing record. And are there any objections to Exhibit 203, the errata sheet for Mr. Murray's testimony? Exhibit 203 is admitted onto the hearing record. And public counsel, go ahead.
Tender Mr. Murray for examination.
Any cross-examination for Mr. Murray from MIEC,
No questions, thank you, Your Honor.
MECG? Staff?
No questions.
Ameren, Missouri?
No, thank you.
As an alternative, you're proposing that the securitized bond rate be the carrying cost rate. Is that correct? Yes. Can you explain your logic for that? My logic is that's the financing charge that ratepayers are ultimately going to pay when the bonds are issued, and the securitized utility tariff charge. Tariffs go into effect. The whole idea is to provide some compensation for this asset that is no longer used and useful by transferring the rights to the assets to the bondholders, buying the bonds in the I can't remember the name of the special purpose entity, but that's ultimately what's going to be the most current reasonable cost that could be associated with a recovery of a regulatory asset over a 15-year period. What do you believe will be the effect of that on Ameren, Missouri? I don't think there'll be much, if any, effect. Then why propose it? I propose as an alternative, just thinking about the logic of the whole idea of doing securitized bond transactions is to minimize the possibility that a full authorized rate of return will be allowed on a plant that's no longer used and useful, but at the same point, or at the same time, still trying to provide some fairness to ratepayers by this whole innovative process of securitization, and that is the finance rate that's the carrying charge that will be charged to customers. Thank you. I believe I may have skipped over, and did I ask if there were commission questions? Okay, I hear none. Any recross? MIEC? No questions, thank you. MECG? Staff?
No.
Ameren?
Yes. Good afternoon.
Good afternoon.
So about this alternative approach that you mentioned, when will we know what the finance rate in the bond is going to be?
It'll be sometime within 2 weeks. I guess you got the issuance advice letter that is supposed to be a draft provided 2 weeks before going to the market. So the estimate, you might have an estimate. I don't know if you'll have an estimate of the bond rate at that 2 week period. You'll definitely have it, obviously, when you have the issuance advice letter.
And the carrying costs we're talking about here are carrying costs for the time period after the asset's out of rates until the bond is issued, right?
That's correct.
So you could be incurring carrying costs and not know what the rate is.
Yes, but my understanding is cost and whether they're above or below estimates, can be trued up. I think that's been discussed.
How does the company book it on their, how does the company put it into their books if they don't know what the carrying cost rate is?
I mean, when I've reviewed the issuance of vice letter work papers, the, it's, at that day is whenever, you can review the carrying cost charges that are charged for the, the securitized bond amount. I think that's the time when you would, hopefully get it as close to the, the possible or potential bond cost as possible. I think that's also when you'll review the details of, what in the securitized bond amount are expenditures that have already occurred versus estimates of decommissioning cost and cost yet to have capital deployed to support. So I think there's a lot of things that go into the issuance of vice letter and trying to get this fine tuned. Now, as far as exactly where it would be booked, yeah, I'm not an accountant. I don't know where it would be booked.
All right, let me try this a different way. Let's say that the Office of Public Counsel, let's say the commission allows Ameren to securitize, and the Office of Public Counsel decides to appeal. Okay, in that scenario, the carrying costs would apply to that time period, right? That approximate year for the appeal.
I object to this. I think she's gone beyond the scope of the commission questions, which we're inquiring as to public counsel's logic for proposing to use the bond rate.
Response?
I mean, you had him describe how it would work, and I'm following up on that description.
I'm going to overrule the objection. Please repeat the question.
Absolutely. So I want you to make an assumption that the commission grants Ameren, Missouri permission to securitize, let's say $500 million, just as a number, and the Office of Public Counsel appeals that decision. So there would be a time period in which Ameren, Missouri would get carrying costs, but the bond is not issued, right? It's delayed a year because of the appeal.
Yes, I understand.
So there could be a significant amount of time without a carrying cost rate, is my point. That's been approved. Unless you're saying the commission should grant some provisional rate that later gets trued up. Is that what you're proposing?
Oh, the securitized bond rate, yes. Whatever the best estimate is at the time.
Would that be the company's estimate of 5.59%?
I think Mr. Davis provided an updated estimate of 5.33%, but that's going to be changing. I mean, since he provided that estimate, within the last few days, bond yields have increased, 30, 40 basis points. So it's going to be constantly fluctuating.
Okay, that makes more sense to me. Thank you.
Do you have any further questions?
Oh, sorry. That's what thank you was meant to impart to you, but it did not. No more questions.
I didn't pick up on it this time. My apologies. Any redirect from public counsel?
Thank you, no.
Mr. Murray, you may step down and you're excused. Thank you for your testimony. I believe we have one witness left, and that would be Mr. Majors for staff.
Yes, Judge, staff would call Mr. Majors to the stand for the umpteenth and final time. And since this will be the final time, and his testimony has already been marked, I believe it was the rebuttal testimony and several schedules, which due to their length, I don't think were physically attached, but were at least provided at the same time and with the rebuttal testimony. I believe those were marked as Exhibit 110 and 110C, and then the Sir rebuttal was, I believe, just a public version of Sir rebuttal, was marked Exhibit 111, and they've been, like I said, marked, and I would offer those at this time.
Any objection to offering Exhibit 110, the rebuttal testimony of Keith Majors, onto the hearing record?
You mean receiving onto the hearing record? You said offering onto the hearing record.
Admitting onto the hearing record. I hear and see none. Exhibit 110, the rebuttal testimony of Mr. Majors, including the schedules, is admitted onto the hearing record, both public and confidential. Any objections to admitting Exhibit 111, the rebuttal testimony of Mr. Majors, onto the hearing record? I hear and see none. Exhibit 111 is admitted onto the hearing record.
Thank you, Judge. I tender Mr. Majors on issue 21.
Any cross-examination from MIEC? No questions, thank you. MECG?
No, thank you, Your Honor.
Public Counsel?
No, thank you.
Ameren, Missouri?
Thank you. So, Mr. Majors, you'd agree that the carrying costs that we're discussing here today are mostly only incurred if there's an appeal of the commission order. You agree with that?
Well, I think that they would increase if there's an appeal of the commission order, but it's really the uncertainty of the retirement versus the bond issuance. And so an appeal would lengthen the amount of time, therefore increase the amount of carrying costs that were ultimately incurred.
Thank you. Do you agree that the company's long-term investments in the Rush Island plant are currently being financed through a mix of its debt and equity?
Yes.
And that cost of debt and equity is the company's weighted average cost of capital,
Yes.
which in this case you recognize is 6.821%.
Yes.
And also, I think you'd agree that the cost of debt component is less than the weighted average cost of capital.
Yes.
No further questions.
Any commission questions? I believe I just have one question for you, Mr. Majors, and I'm just going to ask if the position to allow carrying costs for the period from the retirement of Rush Island to the time that the securitized utility tariff bonds are issued at Ameren's current long-term debt rate, is that consistent with what the commission ordered in the Asbury amended order?
Yes, it is.
Thank you. Any recross based upon bench questions? MIEC? No questions, thank you. MECG? Public Counsel?
No, thank you.
Ameren, Missouri?
No questions.
Any redirect from commission staff?
Very briefly, Judge. Mr. Majors, in response to the judge's question about the, I guess, Liberty order, you said the carrying cost between time of retirement and issuance of bonds was allowed at the company's long-term cost of debt in that case. Is that correct?
Yes, that's correct.
So the weighted average cost of capital was not used in that case?
Yes, that's correct.
Okay, was that different in the, well, I guess there wasn't a retirement, but between the authorization of the financing order and the actual issuance of bonds in the Evergy case?
I'm going to object. This goes beyond you asked about Liberty, not Evergy.
Mr. Keefe?
Well, I'm asking Mr. Majors to compare what was done in Liberty with what was done in Evergy. I think it's
I'm going to overrule the objection. You can go ahead and ask.
if you remember, Mr. Majors, in the, how do those two cases compare?
I unfortunately, I should know, but I don't.
Okay, that's fair enough. I have no further questions, Judge.
Okay, I believe, Mr. Majors, I believe you can step down, and I believe you're finally excused.
Thank you.
All right, that was our last witness on our last issue. Can we go off the record for a moment? Back on the record. All right, we had talked about reserving some numbers. I believe I was missing two things that I wanted, and those would be for commission exhibits. And I believe I would be at commission number 606. And I will reserve 606 for the 2019 district court decision. And public counsel, you said you would provide that to me?
Be happy to.
Thank you. And what was the other item? I have one summary. I have a summary determination. I have the transcript from March 28th. I believe attached to Mr. Majors, I have the 2017 and the 2021 district court decision. And was it indicated there was or was not an additional summary determination motion?
I thought that there was, and was there, what, well, I thought that people said there was, but then said there wasn't, so
Yeah, there was
I was a
some
little
confusion on
confused
my
about that, to be perfectly honest.
Well, hang on a moment.
We seem to believe there were two, Judge. Two summary, judgments.
Give me a moment. I think I can access them, actually.
Well, at this point, we can take all the time we want, so let's just slow down and do things as correctly as we could.
Where'd I put it?
Judge, do you require the commissioners any longer?
Oh, I apologize so much, Commissioner Holzman. I'm sorry. I'd said I'd gone off the record, so you probably didn't hear me. I apologize. Yeah, this is all housekeeping stuff. So no, if you want to leave, none of this is going to be interesting.
All right, thank you, Judge. We'll talk to you soon.
Thank you for your participation. I'm sorry that I didn't get that to you.
Judge, maybe I could make a suggestion. You could reserve another number, and then if a party thinks there's another one that ought to be late filed, they could do that. You give the other parties a chance to, object or not. Unless Mr. Williams finds it here.
I actually have gotten, I have them, I obtained them off of Lexis, so I don't have them in terms of dates but I have citations, so the issue then is which ones I have are the same as what you already have, so that I know which one's different.
Okay. Hold on just a moment. Why don't we do this part off the record?
Sounds good.
On the record? How long do the parties need for that? Would next Wednesday be sufficient for those to be filed?
They would, from our standpoint, yes.
I believe so. I think it's a matter of the parties just reaching an agreement as to what they are and seeing them.
Okay, well, I will set a time. Any late filed exhibits regarding summary determination motion orders at the district court involving I don't know how to word this. Hold on, give me a second. Regarding the liability case or the remedy case, does that cover it?
Right, in 4:11 CV 00077-RWS. That's the case.
We'll go with that.
Thank you.
Those are due no later than the 24th, and I will issue an order allowing 10 days to file objections.
Will you be issuing an order saying what you just said?
I wasn't planning on it. Would you like a written order?
I was thinking it might be helpful, yes.
I will try and get one out tomorrow.
Okay, thank you.
Thank you, Mr. Keevil. I'll issue a written order to that effect. Let me write down that case number just so that I've got it right, since I won't have the transcript to do it from.
It is 4:11-CV crash Victor -00077 Randall William Sam.
Okay, thank you. I think that is sufficient for that. Now I'd would just briefly like to go through exhibits. I do not at this point want to draw a distinction between provisionally admitted versus admitted. I think that will unnecessarily lengthen this process. So I'm just going to go through, starting with Ameren, Missouri's exhibits. Do you have your exhibit list in front of you?
Yes.
I have 1C, 1P, 2, 3, 4, and 6. Was 5 offered?
We show that it was offered and admitted on our list.
And it's entirely possible with everything going on that I did not.
Well, that was on the 15th.
It would have been the first day. That's when Mr. Sagal was here.
I reflect that too.
And remember, he was excused then after, so.
Okay. Exhibit 7, 8C, 8P. I don't have a notation on this, maybe somewhere else. Was Mr. Whitworth's testimony admitted?
I show 9C and 9P were, well, yes, I show 8C and 8P, and 9C and 9P were both offered and admitted.
Okay. Hold on, let me pull up my paper from the 12th for Mr. Homestead. I have exhibits 10 and 11 as admitted.
Okay, thank you.
Exhibit 12, I failed to make a notation.
We show 12, the confidential and public version admitted.
Oh, wait, I did have the 12 public, so it was just my failure to mark the 12. All right, and then 14C, 14P, 15C, 15P, 16, 17C, 17P, 18C, 18P, 19. And here we're going to bounce around a little bit because we're going to go off where I've written numbers kind of out of order. And I believe we have, do you have 20 C and P as being admitted?
Yes.
Thank you.
And Judge, you didn't, unless I missed it, you didn't say 13.
Yes, 13 was admitted.
Okay, thank you.
And then I've got 21, the correction to MCB-D2. I have 22, SCW-20 correction. I have 23 and 24, the direct and surrebuttal of Mr. Reed. I have 25, which is OPC-DR 8506. I have 26, which is OPC-DR 1105. Was there a 27?
No.
I think there was something that was going to go in there and it ended up not. Okay.
I don't even think it got marked, maybe, but it would have been 27. Was it? Okay, marked but not offered.
Okay. I'm just going to do, I have both of MIEC's exhibits as being admitted, and that is 550 and 551, which is Brubaker's rebuttal and surrebuttal.
Yes, Your Honor, and I apologize for my mistake, but I'm filing a new exhibit list just to conform with the right numbers.
Did you file it or just email it to me?
Well,
filed.
we filed it, but it was filed, but it was mistakenly filed in the wrong case. So I'm going to refile it as a corrected exhibit.
No, I believe we're on the record.
Yes, we are.
Let's go off the record for just a second. Go through staffs. Okay, for staff, I have admitted Exhibit 100, Exhibit 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, 111. I do not have anything marked as to Mr. Davis's testimony.
Yeah, Judge, we offered, I show that as having been marked and received on 112, as 112.
Okay, thank you.
Now, maybe the transcript.
I'm sorry, I did not hear anything that staff is saying.
Oh, you're leaning back, and since the court reporter is only available online, she can't hear you if you're not talking into the mic.
I show Mr. Davis as having been marked and received as Exhibit 112, both public and confidential. Now, maybe the transcript from Monday will disagree with me on that, but that's what I show.
If we run into that issue, we will address it.
And Judge, as you were going through the numbers up to 112, you didn't do the public and confidential, or P and C like you were doing for Ameren's, which concerns me a little bit because most of ours had both public and confidential, but not all of them.
I hate to ask, are we on the record now?
Yes, we've been on the record.
Thank you. I did it the way I did it for Ameren, Missouri, because they separated them out that way. You have a checkbox where it has a confidential, so where there was a confidential and a public, they were just both admitted under the same number.
Okay.
And that's kind of generally how I prefer to treat them.
I agree, Judge. I don't think it's necessary to actually, they're really one exhibit with two
Yeah,
versions.
I mean, really, all you need is the number. You don't really need that confidential and private because it's the same testimony and just the availability of it.
Okay. Now,
All right, let's go on to, I've got,
I was gonna say, staff apparently had some additional exhibits when I wasn't here, so.
I have,
Okay.
I have 113, which is the, we just stumbled across that. That was the summary determination motion. I've got 114 admitted. That was the DNR rules. I've got 115. That is the federal SIP. I've got 116. That is the summary determination motion that I spent so much time looking for. I have 117. That is the district court transcript from 328. I have 118, and that's the capacity IRP. And then I have 119, and that is reliability requirements. Does that comport with what everybody has?
That's what I showed, Judge.
Except I think the descriptor on 113 is.
I have it as A1. There's probably a better descriptor for that.
It's Whitworth's summary judgment declaration.
Okay,
It's
what?
Exhibit A1 to a motion.
Any objection to, well, I don't need an objection for that. I'll just change the descriptor to, I will change the descriptor to,
I mean, I don't really care, but I thought you might want it to be more
you said
clear.
Whitworth Declaration?
Yes,
Is that sufficient?
it is for me.
All right.
And then 116, I think you said it was a motion. That's actually the 12116 summary judgment order. It's an order.
I have that as federal memorandum and order.
Yep.
Okay.
Thank you.
Okay,
Any
moving.
other revisions you'd like to make to my exhibits? No? Okay.
They weren't pre-printed, Jeff. I was just trying to make sure the records are clear as to what they were.
I'll set a hearing date. Tomorrow's free.
Tomorrow's free now, yeah.
Yes. Let's go with OPC. Exhibit 10, Homestead Direct and Sur rebuttal. So
Wait, that can't be right.
that is not OPC's. That is, I wondered where I put that. I take some weird notes. I've got Exhibit 200, Letter to Detroit Edison. I've got Exhibit 201, which is Murray's rebuttal. 202, Murray's Sur rebuttal. 203, Murray's errata sheet. 204, Seaver's rebuttal with corrections. I don't have a 205.
Mansell Payne's rebuttal,
Thank you.
and that should have been yesterday, that it was admitted.
I remember that, so I'm fairly sure that was done. 206, Robinette. 207 is Riley's rebuttal. 208 is Riley's Sur rebuttal. 209 is Shaban's rebuttal. 210 is OPC DR 8515.
That's what you call it.
Oh.
It's actually UE's response to it, but.
Oh, okay, I'll put response. And I just had them out of order. I have Mr. Payne's entered just below that.
Oh,
So
okay.
as 205, I just had it written out of order for some reason.
And then.
I didn't have an OPC witness list, so I just was writing it up. And then finally, 211, Mantle rebuttal.
Sur rebuttal, but yes.
Oh, allow me to fix that.
Judge, related to this exhibit list issue or matter, Monday, we normally give the court reporter who was here at the time a copy of either a disc or all the testimony or whatever. I did not give the court reporter anything on Monday, although I had it here in my wagon. And today, since we have no court reporter physically here.
I am retaining, I'm sorry, I cut you off, but I think I know where you're going.
Yeah.
I am retaining all the exhibits. I've instructed, my staff has informed the court reporters that if they need information regarding stuff, they're to contact my paralegal. And if they have questions about acronyms or names or anything in the testimony that needs to be clarified. My understanding is we have expedited transcripts to the 24th. I will do my darndest to get them on as quickly as they are received, but obviously we've had some things that need to be stricken from the record and such, and so I want to be sure those are done. And given the length of time for this, I will review them and post them as quickly as I can. I will, if there are corrections to be made, I will see that that is done as expeditiously as possible.
Judge, related to that, as I understand that, then where I was going with my question was, we don't need to give anyone when I say we, I mean staff. I don't know about you. I'm not speaking on your behalf, but we don't need to give anyone additional copies because you were given copies of, or you already had the copies of the pre-filed stuff.
And that's what we're working off of. I believe what I've said before is if it was filed electronically and you want to label as an exhibit, there's no reason to chop down a tree to do it.
Right.
And so if it's been filed electronically and it corresponds, then it will be, my legal assistant will go through, we'll be doing that next week, going through, marking each exhibit, and moving it onto EFIS.
Okay. Now, there were certain things like,
So they will, it won't just, it's not just that we're labeling the pre-filed testimony. It will be refiled separately in EFIS as an exhibit.
and will that, I mean, I assume were then given copies during the hearing of things that weren't pre-filed but were offered as exhibits.
Those will be scanned.
And those will be scanned, right. So that's where I was going here. We don't need to give you anything at this point, like bring in copies, extra copies for the court reporter, don't need them. Computer disk for the court reporter, don't need it. Nothing. You need nothing other than these late filed things that you talked about earlier. Is that correct?
That is correct. I'm trying to streamline this process as much as possible.
Thank you.
Although in the future, if there are corrections, I would like errata sheets, because that is taxing on me. All right, let's talk. I believe we are to commission exhibits. And so I had asked for the work papers supporting the schedules for Mr. Lansford as Exhibit 600. For Mr. Majors, work papers for supporting his schedule KMS1, I have that as 601. Riley's work papers, 602. Murray's work papers, 603. The Mr. Lansford base mat coal work paper, tab MAT ampersand SUP2, as admitted. I have, and then we're to 606, the 2019 court remedy that OPC is going to get to me, as well as 607 for, well, do I need to, there are multiple, we'll just treat all of those as late filed exhibits.
I think you'll end up needing maybe more than 607,
Yeah,
but
so,
I don't know
and
how
since
many.
I don't know how many, what I'm just going to do is I'll issue order tomorrow for late filed exhibits and word it accordingly based upon what you said about Randall and all. Does that cover all the exhibits?
I do have a question for you. We did not do errata sheets for our corrections. Would it be helpful for you if we put those together and provide those to you?
That would be fantastic.
Okay, thank you.
It's okay if we do that, I don't know, by next Tuesday or Wednesday. I mean, give us a couple days to figure that out.
Absolutely.
Okay.
Thank you. Trying to think if there's anything else I need to take up at this time. it looks like I have, the way it is right now, I have initial post-hearing briefs to be filed May 10th, 2024, reply briefs for May 17th, 2024, and my statutory deadline is June 23rd, 2024, but as a matter of practicality, I believe that is a weekend, and my actual deadline is going to be Friday, June 21st. Okay. Is there anything that the commission needs to take up before I adjourn this hearing? I hear nothing. I will say to everyone, thank you all for your time. I know that I have pushed really hard this week. And so thank you for that. That's all I can say. Thank you. And we are adjourned. Let's go off the record.
Judge, before you let me go here, is there any way I can get the email address to your assistant for the